Yes, call the list.
My lord, item 627. It was mentioned for extension interim order, my lord. Application is tagged, my lord, but it has come, my lord, under the heading new motion. Let the matter appear to extension interim order next Tuesday.
627.
627.
When the interim order expired?
My lord, today.
Will be expiring today.
Yes.
Who is appealing for the other side?
My lord, I serve, my lord, original revision application as well as extension of application.
Nobody has appeared.
No, nobody has given me intimation.
627.
Yes.
627 Monday extension of interim order.
But I am seeking leave, my lord, to filing, my lord, the revisional application without certified copy, annexing the server copy. Order has been passed, certified copy applied on 17th.
What is the grave urgency, Mr.
The
Mukherjee?
next day, my lord, it's arising out of, my lord, the commercial suit. The next date is of 7th of March. If I couldn't able to file and show that before the commercial court, your lordship knows, my lord, the commercial court, my lord, there are, my lord, criteria they will
file. Why the leave is leave without the certified copy?
I have, my lord, applied, my lord, but
You have given the photocopy of that application.
Is here, my lord. I have not annexed to the
Tag it along with the
very well.
leave to file without the certified copy, but with the server copy.
Server. Yes, my lord. I have annexed.
So with extreme urgency, I'm mentioning this matter. The petitioner is a disabled lady, my lord. I have
What do you want?
on 7th March, the date is fixed for the lower court. We have sought adjournment twice.
Please mention on Monday, Wednesday. Yes, call the list.
May I mention, my lord, the listed matter, item number 119. My lord,
109.
119, my
lord. 119.
119.
Yes.
My lord, it was there, my lord, on Wednesday, possibly, or Tuesday.
It's not appearing.
No. It was there, my lord. The other side came and said that, my lord, they are appearing. So, my lord, your lordship was pleased to direct service. I have no difficulty. Your lordship was pleased to, my lord, direct that it will appear today. It is appearing. In case it is not taken up, kindly take it up.
What is the urgency, Mr.
I will
Mitra?
tell your lordship, my lord, the whole difficulty is a section 8 application filed after 3 years has been allowed. Same points were taken, my lord, in Order 7, Rule 11 application, my lord, that was dismissed. Thereafter, my lord, written statement filed, and then, my lord, the application made. My difficulty is, my lord,
Section 8, if it is allowed, is it not an appellable order? Section 8 of the Arbitration and Conciliation Act, is it not an appellable order?
I checked.
Kindly check up because
Yes, I did, my lord.
Arbitration Conciliation Act আছে নেই কেন বলেছিলাম তো Arbitration Conciliation.
If it is rejected, yes. If it is allowed, no.
But if it is allowed, the effect is suit goes.
Yes.
Suit goes.
I know, but
if the suit is dismissed,
language
suit will come within the definition of
the suit was not dismissed merely
because Section 8 allows
means
suit,
that
suit is dismissed. So whether it falls within the expression decree.
Kindly take it up, my lord. Not in the monthly list, my lord. That is my only prayer, my lord.
Mr. Mitra, do one thing. If it appears, please mention after because can you not come on next Wednesday to mention? Is it so urgent that it cannot wait till Wednesday?
I'll tell your lordship why. My lord, I would not have normally done this. The difficulty is, my lord, my application under Order 39, Rule 1 and 2, my lord, which hearing was, my lord, concluded. My lord, that has got struck.
Because of this.
Because of this. Now, my lord, I have records, my lord, to show that they are trying to transfer the property. That is the only difficulty.
119 টা বুধবার দিন 119.
May I be permitted to mention one extension of interim, my lord.
When it is expiring?
My lord, it is expired, my lord.
When did it expire?
My lord, in December, my lord. My lord, kindly consider 5th is the next date.
You have filed an application?
Yes, my lord.
So let it appear under the heading application.
5th is the date for, my lord, in the
application it will appear.
My lord, it is there in the list, my lord, 613, my lord. Kindly extend, kindly take it up, my lord. 5th is the date, my lord. They are not giving time. Once they have given time, my lord. My lord, kindly, my lord.
Extension of interim order, Monday.
My lord, may I be permitted to mention, my lord, CO 1194.
What do you want?
Huh?
What do you want?
My lord, the matter was fixed.
What is your prayer?
Prayer for rejection of.
What do you want? Upgradation, inclusion?
Inclusion.
Please come on Wednesday. Please come on Wednesday.
Sergeant, my lord, last.
Please come on Wednesday. Yes, call the list.
Yesterday, my lord, rejected.
Yes, call the list.
My prayer for adjournment.
Number 1, Your lordship delivers the judgment. Would it be my lord's pleasure to consider the application that has been?
Yes,
Could I just pray for your lordship to deliver the judgment first and then look at the application?
Because Lord, once the judgment is delivered,
I am not as experienced as him. It is like a result day for me.
Lord,
That's the only reason.
Lord, the issue is slightly more serious. Lord, if your lordships kindly, Lord,
Mr. Banerjee, only one thing, Mr. Bandopadhyay, I'm
I
expecting
heard.
this to, he mentioned this matter. So I asked him to wait for 2 days. And your advocate on record was there to take instructions. So whether you will support a litigant making allegations against the appearing
No, so
counsels,
it's-
I'm asking you
No,
as an officer of the
an
court.
act of
So
contempt.
that was the
question doesn't
Mr.
arise.
Bandopadhyay, Mr. Banerjee, that was the submission of Mr. Bandopadhyay. I asked the advocate on record or any junior advocate who appeared on that day to talk to your client and to revert back to Mr. Bandopadhyay. I think day before yesterday it was mentioned, nothing was communicated from your end. Was it not expected from your end to communicate with Mr. Bandopadhyay with regard to that?
200%, my lord. I have come into
So
the
what
matter.
is your instruction?
I have come into the matter yesterday at 9 o'clock. Gives me 1 minute. I'll just show to your lordship. Kindly open the application once.
Lord, it's my application.
No, I'm not saying, I'm not showing anything from the application except the praise. Kindly comes to praise C. This, your lordship will grant immediately. Also, kindly direct both the parties, this I have taken instructions, both the parties to not make any statement in the media.
But before that, a rule is necessary.
No,
A rule of
that-
contempt is necessary. Lord,
that-
may I place the
acceptable.
application?
Lord,
Lord,
may I
may I
just
place the
indicate one
application?
thing? That order also your lordship will consider that both parties will not make any statement about this matter to the public or to the media while this matter is
Mr.
going on.
Court, that is, I think,
No, this
Mr.
is the
Court,
best
both
I
the
could have done
parties
in this
are
situation.
public figures.
Lord, kindly-
Both the parties
no.
to the
Lord,
suit.
this is nothing to do with public figure. This is, Lord, protecting a senior advocate who's appearing before your lordship. Now,
That Mr. Banerjee is agreed to.
no, he is not. He is saying future. There is no, Lord, commitment to at least say sorry. Lord, I am really, Lord,
That is.
Lord, I feel ashamed that,
That
Lord,
was-
we are
that was
unable to protect
expected.
ourselves.
For that, I requested Mr. Bandopadhyay to wait for 2 days. Nothing was communicated.
No, that communication should have happened.
Lord, kindly see.
so
So if you agree to that, so why are you not communicating to Mr. Bandopadhyay?
No, I'll tell you, Lordship.
Lord, kindly see page 9. Just not see. Kindly see, Lord, what is the intention. Kindly, Lord, come to page 9.
Yes.
This is, Lord, from the wall. Kindly, Lord, see the last paragraph. এই ব্যাপারে প্রতিক্রিয়া জানাতে গিয়ে কল্যাণ বন্দ্যোপাধ্যায়ের বিরুদ্ধে বড় অভিযোগ এনেছেন সোয়ানসো। শুক্রবার সন্ধ্যায় টেলিফোনেতে ওয়ালকে রত্না বললেন, আমি তো কল্যাণদার কথাতেই শোভনকে ডিভোর্স দিচ্ছি না, উনি তো হাইকোর্টে আমাকে 1 ঘন্টা ধরে কত পরামর্শ দিয়েছেন, বলেছেন সোয়ানসো ইজ কত সংসার ভাঙছে এক্সেট্রা, এই ডিভোর্স দিবি না, তুই লড়াই কর, আমি তোর পাশে আছি। Lord, this touches upon the professional ethics of a senior advocate, that he has advised her and now, Lord, he is appearing for the other party. This is a clear case of contempt. And Lord, I am fortified by a judgment of our High Court. Lord, I want to, Lord, rely on this judgment. A contempt rule should be issued before, Lord, anything else happens. Kindly, Lord, have a look at this judgment.
You invited this problem, Mr. Banerjee.
They are inviting it. Absolutely inviting.
I'm not saying you this, your client.
9 o'clock yesterday.
Lord, please come to page 891. This is, Lord, reported, Lord, it's a Indian law reports. Kindly, Lord, come to internal page 891.
Lord, could I get a copy of what?
Yes, of course. Reported. Lord, kindly come to that paragraph. Another ground upon which I think Mr. N.K. Basu's argument was right was this. He pointed out that if aspersions are cast upon a particular advocate, party by reason of the fact that the advocate had undertaken to defend certain clients, these aspersions have certainly an effect in tending to deter the advocate from continuing with his duties for his clients. And in certain circumstances, in embarrassing him, in discharge of those duties, one is not so familiar with cases of contempt of court arising out of comments upon advocates as one officers. One is with cases arising out of comments upon judicial officers, but it is pointed out by the highest authority that the court's jurisdiction in contempt is not exercised out of any mere notion of the dignity of the judicial officer, but is exercised for the purpose of preventing interference with the due course of justice. And it is quite possible to interfere with the due course of justice by making comments upon an advocate in the way of his profession. It goes without saying that unlike a judge, an advocate is quite entitled to be engaged in politics as much as he is liked, and comments upon an advocate's political opinions and activities would be in no way be contempt of court. But the comment upon an advocate which has reference to the conduct of his cases may amount to contempt of the court on exactly the same principle that while criticism of a judge and even of a judge's judgment in court is permissible, criticism is not permissible if it is made at a time and in such circumstances or is of such a character that it tends to interfere with the due course of justice. Here again, I think the tendency is very slight, but if the question be whether this is a proper comment, the answer must be no. It is a comment which tends to embarrass the advocate. Now, my lord, kindly see she doesn't stop there. She goes and attacks the family. Kindly, my lord, have a look at this.
Page 11.
Kindly, my lord, come to page 11. Is this a fair criticism? And my lord, kindly see, my lord, the third paragraph. Erpori purono kasundi tene. So and so dabi. Kindly, my lord, have a look at that.
Junior counsel assisting us.
Is this not a personal attack?
He has no political affiliation.
Mr. Kaur, this is a case of criminal contempt.
This is a case of civil contempt. Lord, I tell your lordship why.
Administration of justice.
Administration of justice, but Lord, in so far as the advocate's Lord reputation is concerned, that is at stake. Lord, what will people think? That Lord, he is a man. Palti khachen. That's the expression. Palti khe galen. Page 10 at the top. That is the expression used.
Yes.
Lord, please kindly, Lord, kindly see that, Lord, this is not a criticism. This is a personal attack. And Lord, the dignity of the advocate is at stake.
Here, Mr. Kaur is interference in judicial proceedings. It amounts to criminal contempt.
Then
Then I have to
Then Lord, kindly do one.
Yes.
Kindly do
I
one.
can give you leave to file
No,
an appropriate application.
we will, Lord, approach the Advocate General for the purpose of getting, Lord, say under section 15, and Lord, in the meantime, issue a gag order, so far as she is concerned.
Lawyers.
So that there is no further comment on Mr.
I-
Bandyopadhyay.
I am saying,
Because, Lord, I am not, Lord, concerned about the parties. Parties are litigating. Let them do whatever they want.
CD
But,
your
Lord,
lordship
as-
will grant immediately. Prayer
See, Mr. Banerjee
Immediate.
is
Not only see, I am saying that I expected Mr. Banerjee to come up and tell your lordship that she is willing to, Lord,
I'll tell
at
you
least
lordship what has happened.
express a-
But it is extremely difficult for me to, in this situation, really try to defend or even explain what has happened. Because once Mr. Bandyopadhyay gets involved, just relax. Once Mr. Bandyopadhyay gets involved, then I immediately become a part under that umbrella. Then I stop becoming a representative
that
of
is
my. But I'll tell you lordship,
one
what has
thing-
happened
one
yesterday. I've
thing-
spoken to the client.
Yes.
And it's also my duty when I'm representing her, at least to explain what has happened. These reports that your lordship has seen, I have seen those interviews. These actually interviews that are given. Questions that were put to my client do not form a part of this article. The answers only come. Questions that were put were regarding Mr. Bandyopadhyay's submission in court about her father being very colorful and about her father having such a colorful life that he could explain to Mr. Ranjan Bachawat what it was.
Mr. Banerjee,
Was she in
one
court
thing
to
is
argue
that
the matter?
that can be your defense in their
Correct.
application. I'm not on that. So you can fight it out. They will be entitled to
No,
take out
but
an application. You can fight it out. That
Whether
is
I
one
do
thing.
it or somebody else does it once Mr. Bandyopadhyay. But there's one issue that I would like to address, your lordship. Well, yesterday I had a word with my brother, my elder brother. He told me Mr. Bandyopadhyay wanted to speak to me. I tried to give him a call. I could not reach out. Later at night after work, when I met my brother, he said that Mr. Bandyopadhyay has explained that his daughter is also getting threats. So when I come into court today, I called her and she's told me that from some particular number. Now this is when I I'm not saying switching sides, but this has to be done. There's some particular number from which she has been receiving threats. This I will request your lordship. She's lodged an FIR. This your lordship will direct the police to immediately make an investigation, and your lordship will monitor this investigation. This number is there. It's ascribed to an individual. These persons will have to be hauled up.
But
Well,
what
this
about
can't
Mr.
go-
Bandyopadhyay's reputation?
No, no,
They
that
are more concerned about
I am a
him
little
at
more
the
concerned
present moment.
about this. I'm a
There
little
are
more
two things,
concerned
Mr.
about
Kaur.
this.
Please
But
take
please
your
monitor this investigation.
Banerjee, please give me a minute.
Just on the point of law,
Page
Madam,
7.
just on the point of law, even the court can take a suo motu cognizance.
Yes.
Matter may be heard by the division with criminal contempt jurisdiction.
Yes.
Every court can take the judicial notice of that. Therefore, this is the bench where I have argued.
Yes.
Where I have argued. Your lordship takes, this is, I am pointing out to your lordship. Your lordship takes the no, issue the criminal contempt. Issue
Only-
rule.
Yes, Mr. Bandyopadhyay, you are absolutely right. But only one thing, because this is an application taken out, because otherwise, if this is kept pending, the main matter will be kept pending. Unnecessarily a
Contempt
proceeding
will be
between the two.
No, that's not, that is a different, if a criminal proceeding, contempt can be decided later on, that's not.
Yes.
Your lordship can deliver the
That is-
judgment, but
Yes.
your lordship kindly issue a suo motu rule of contempt. What I am submitting, it is not required to go to the Advocate General or anybody else. What I am submitting, if suppose let's assume a contempt has been committed before your lordship's court. What your lordships will do? Your lordship will suo motu contempt.
Yes.
Under
Cognizance can be
Under section
taken.
14.
No difficulty on that. Because
Cognizance-
there are in page 7, there are 3 prayers. With regard to prayer C, if Mr. Bandyopadhyay, are you having a copy of that?
Yes.
Please come to page 7.
Yes.
There are effective 3 prayers. Prayer D is omnibus prayer. So prayer C, Mr. Banerjee is agreeing to that. That an order immediately prohibiting. So he is agreeing to that. There is no
No
difficulty
difficulties, it's
No
all
difficulty.
right.
with regard to that. With regard, because this is a CAN application taken out in connection with a civil revision. I will give you liberty to take a fresh application on that. I will consider.
No, may I tell your lordships?
Yes.
Just a suggestion to your lordships.
Yes.
Criminal contempt is initiated when it is informed to the court.
Yes.
I am informing it. You lordship can dispose of this as the application. There is no difficulty. Passing an order, but rule of contempt we issue.
Yes.
Then the application would not be pending. Application would be disposed of.
But something has to be forwarded before the if cognizance is taken.
My lord can refer it. It doesn't. Main matter is not judgment. Will not. It will not affect the issuance of a rule. There are so many matters where the matters have been disposed of. Thereafter, also rule of contempt has been issued. Rule of contempt has to be issued. Suo motu rule of contempt. I waited. I
Yes,
waited.
I asked you to wait. I asked you to wait for 2 days. So
I waited. And that is the last day. That's the reason I have had to file.
is what I told Mr.
I
Banerjee.
don't enjoy any pleasure. I don't enjoy any pleasure to file this one.
This ego, that Lord, not even a sorry.
My lord, may I tell you, lordships, lord, what is now a
Mr. Banerjee,
tendency
what
has
is
been
your instruction?
lord, a tendency has been grown up.
Mr. Bandyopadhyay, give me a minute. Mr. Bandyopadhyay, give me a minute. What is your instruction? Can you come back at 1?
Instructions regarding. I was.
That you have to instruct.
I am in a very. Once he.
That
gets
you have to
involved, I
instruct.
don't know what to.
Mr. Banerjee, I am giving you 1 chance. That is why I am keeping it at 1. Or if you want at 2.
Could I just make one prayer? One prayer. Your lordship will allow me to come back on Monday.
This, Mr. Banerjee, otherwise this delivery of judgment, that are between 2 parties. So this matter cannot be kept till Monday. Then I have to detach this. I have to pass certain orders on this. That is why I am asking you 1 PM or latest at 2. Because I have said that today we will deliver judgment in the main matter. This is a subsequent thing which has
I
happened.
don't try then.
This is a
Well,
subsequent thing which has
I'll
happened.
come back at 1.
You come back at 1. If you have something, please communicate with Mr. Bandopadhyay prior to.
That should have been done in the last 2 days. I don't know why. I'm told.
So
that
now,
it
since
was-
you are here now, so do that, communicate, you personally communicate with
No, no,
Mr.
that of course. My lord, once I got to know yesterday from my brother, I called him. He probably must have been in the meeting.
Maybe,
I called him. Yeah, man, if he's there, what can I? It's embarrassing for me to even be here. I should have actually been on that side. But then,
Mr. Bandopadhyay, will you be available if Mr. Banerjee contacts you prior
Yes,
to
yes.
1 at any time?
I will be, I will be in a meeting. Anyway, I no problem. Let him send the text also. I will give the reply also. I don't mind for that.
Mr. Sir, can I
Or
give
I
you
will,
a video call?
yesterday he called me, but that time I was arguing a matter.
All right, so I am keeping,
Thereafter, I left Calcutta.
yes, I am keeping this matter at 1 p.m.
Fine.
So
I
Mr.
will-
Banerjee will take instructions from his client and will communicate to you in the
And
meantime.
Mr. Banerjee can communicate to Mr. Kaur. Mr. Kaur will take decision in this matter.
So Mr. Kaur is there, so
Whoever.
Mr. Kaur will take decision.
আচ্ছা এটা তাহলে এক করে দিন, একটার সময় রাখবেন, একদম কেটে রাখবেন, বেঁধে করে রাখবেন। হ্যাঁ, বেঁধে রাখুন। Yes. This is confirmed.
Item number 2,
এটা একটার সময় রাখবে না? Yes.
I for the petitioner, the interim order was granted till end of February.
Till end of February. What is the matter about?
Matter, this revision is directed against an order by which my application for amendment of plaint has been rejected.
At what stage?
At the trial stage.
Where is your explanation with regard to proviso?
In this matter, I am led by Mr. Anuruddha Chatterjee, my lord. Today is appearing for extension of interim order. Kindly fix a date, my lord.
Mr. Hallar, is there any difficulty for the main matter to be taken up?
No, not
So
difficult.
you have to satisfy me why the interim order will be extended. Satisfy me.
Kindly fix it to Monday, my lord. Monday, my lord.
The interim order will expire today.
I am led by him, since today is appearing.
Where is he?
I don't know, my lord.
Where is your application for amendment?
Page 21, my lord.
After commencement, but at what stage? Particularly at what stage?
At the stage of cross-examination of PW,
Which PW?
my client's witness.
First witness. PW1,
PW3.
PW1 2 completed. At that stage, where is your explanation to with regard to proviso to order 670? No explanation at all.
No, my lord.
What is the finding of the learned trial judge?
Explanation, my lord, at page 22.
22. Yes. Which paragraph?
Paragraph 3 onwards.
Yes. Those are why this amendment is required. With regard to the delay,
Paragraph 4, my lord.
paragraph 4. Mr. Hallar, you are for the plaintiff.
Plaintiff. This is
So Two of your witnesses have already deposed. So your advocate did not go through these papers while preparing himself for the evidence. Is it believable?
And paragraph 5 also, my lord.
I've seen paragraph 5. Place paragraph 5.
Lately on
Detailed discussion perusing all the relevant papers and documents. So two of the witnesses were examined. Advocate did not see the papers, did not consult the plaint, even while drafting the affidavit of evidence in chief. And third witness also, chief was filed. So at the time of cross-examination, how many of your witnesses you have?
this is the last one. This is the last one.
So no explanation.
This is a suit for, my lord, recovery of possession on expiry of lease.
Maybe. So the learned trial judge went only on the proviso, not on the merits. How can I go into the merits? So it is only tested on that. Unless you succeed in crossing the first hurdle, merits cannot be looked into.
Kindly takes it up on Monday, madam. Kindly takes it up on Monday.
Pick up at?
Monday, madam.
Why?
I will
Interim order
extend.
will expire, Mr. Haldar, today.
Well, let it extended. Let it be extended.
There,
Yes, yes. Till end of February.
end of your.
আজকে last দিন. আজকে তার last দিন.
Till the end of February.
After that, it came up for consideration before Madam Justice.
It came up for consideration before Justice Chaudhary and my lord, the matter was fixed on 21st February for final hearing.
Yes.
Anyhow, my lord, interim order is there.
Let the interim order be continued.
Kindly take,
Let it be continued.
kindly takes it up
He
on.
wants till the disposal of the suit.
Uh,
He wants that. He is not opposing.
no, kindly takes it up on.
I'm extending that. Ashun. Mr. Haldar, learned
May it please, madam. My prayers for extension of interim order expiring today.
What is the impugned order?
My lord, section 24 application administrative transfer, my lord.
Administrative transfer.
Section 24 civil procedure.
Yes, yes.
I wanted transfer from one learned additional district judge, Mr. Dinanath Prasad, who at the moment is the 12th ADJ, to any other ADJ in Alipur itself.
Yes.
Because
Now
of-
what happened?
My lord,
That ADJ is still there.
he's still there.
So
My lord, in fact,
administrative transfer, what happened to that? You are seeking administrative transfer here.
yes.
So you have to approach the district judge for administrative transfer.
I am
Within the district,
I have-
district judge. Within the district judge, which of the
concurrent jurisdiction, my lord.
within the district judge knows where to transfer. So I will give you liberty to file an application before the district judge because you seek an administrative transfer. You are saying
My lord, I have come before my lord. This matter has been pending for so long. My lord, can pass that order. My lord. Innocuous prayers, my lord.
these instances,
Hmm.
case was transferred. This was transferred from 6 to
The district judge can, without any notice even.
Yes, but in this case, my case that I've run is of bias
That's the
because
only difficulty is I have to extend, it will be kept pending. This is a matrimonial suit. No, what is the nature of the suit?
probate proceedings.
So probate proceedings.
Mother,
No,
my client is the
I'm not
mother.
on that. So not know when the main matter will be taken up. That is the difficulty. If you go before the district judge from one ADJ to another,
Because my lord,
I think,
my lord, if it's left to the learned district judge, my lord, with deepest of respect, my lord, I submit, I would again be prejudiced because this is what has happened.
all right. Interim order is still
28th of February, today.
today. If it is service filed in court today is taken on record.
For my lord, I am appearing for the petitioner, my lord, led by Mr. Tanmoy Mukherjee, my lord. This is, my lord, it's come under the heading extension of interim order. For extension of the interim order, my lord, passed on 21st November 2024.
What is the impugned order?
My lord. My lord, this is a case, my lord, under section, my lord, 8 and 9 of the West Bengal Land Reforms Act, my lord, for preemption.
Yes.
Then, my lord, I filed affidavit in chief. Then, my lord, in the examination in chief, my lord, I have stated about 6 documents, my lord. But out of 6, only 4 have been marked as exhibits, and 2 have been marked as exhibits, but 4 not, my lord. Out of them, my lord, there is one registered gift deed, one, my lord, registered power of attorney, and also other 2 documents. My prayer for my lord,
Your service.
my lord, that I could not made ready, but my lord, I have the receipt, my lord. I have the receipt, my lord. I have served twice, my lord.
Show me the affidavit service.
My lord, in course of day, my lord, I will file in course of day, my lord.
The learned advocate appearing for the petitioner.
My lord, I have also filed an application for CAN, my lord. CAN, my lord. That is also there, my lord.
Why can? Interim order has expired.
No, no, my lord. Today, my lord. Today
Why
is the
can you have filed?
Today,
Can for what?
CAN for extension of interim order on 26th. My lord, today, my interim order will expire.
All right. Yes, call the next matter.
My lord, I am appearing for the petition. My lord, it is a section 24 matter for transferring the matrimonial suit from Bahrampur to Howrah. My lord, I have already served the copy and
You are appearing.
Yes, madam, for the husband. My lord, there are other proceedings also pending before the Behrampur court. The wife is duly attending there. This is only the delaying tactics. In any case, my lord, this case cannot be
My lord,
transferred
there
to
is
the
no
Howrah
other-
court because my lord, Howrah court does not have jurisdiction. My lord, it's only the Amta court, my lord. Where
Well,
it can be
nowadays,
found.
the lady is residing at his maternal uncle's house.
Well, that
And
is
she is a medically affected lady, my lord. Kindly come to page, once, my lord, kindly come to page 38.
Have you filed your opposition?
No, my lord.
File your opposition then. Ashwin. Interim order is still today.
My lord, till date.
The interim order.
When this matter appeared before his lordship Rai, my lord, his lordship direct both of us to call the person and lady so that they can say before the in their presence whether they want to proceed with this matter or whether they want to divorce. And my lord, my client always want to the divorce.
Well,
They do not-
my client also, my lord.
Both of you want.
Yes, my
And
lord.
my lord,
File
only
an application 13B.
and only
File an
thing is
application.
only
Both of you want divorce. You file an application.
only thing is this that
You have instructions. I can record that and I can
My lord, the respondent is present, my lord.
so I can record your submission.
my lord,
That will take steps for withdrawal of the suit, and both of you can apply under section
my lord,
30B.
my lord, my client, my lord, kindly fix it on Monday. Both of them should have to come. And
No coming business. Both of you take instructions, make your submissions. I will be passing orders. I will not hear the parties personally.
then my lord, kindly come.
After all, you have to take instructions. You can also file an affidavit to that effect.
my
If
lord,
both of you want, you can file an affidavit that you, both of you want to file a petition, joint petition for divorce on mutual consent. If you want, I will allow you to approach the court below, recording that, withdraw that suit, file a mutual. When this matter is when this matter is ইন্টারভিউটা আগে জুন বলেছিলাম, ওটা মার্চ পর্যন্ত করে দিই। Yes, next.
But the interim order extended till today, my lord. The impugned
What is
order,
the impugned order?
impugned order after page 120.
What is the nature of the impugned order?
The the plaintiff file an file a suit for declaration that the gift deed is fake one. The learned trial judge sent this matter before the examination bureau West Bengal for comparison with that fake deed, that which two are also fake. So there is interim order not to give effect the operation of this order, my lord, till
No, I could not follow your submission. Who are you in the suit?
I'm the plaintiff.
You are the plaintiff.
Plaintiff.
You
I
filed a
filed
suit for,
application for declaration that the gift deed is fake one. The
so who
LTI
applied for examination by,
examination.
who applied? Who
The
applied?
defendant.
The defendant
Yes,
applied.
yes.
So why are you opposing? Your
my
allegation
lord,
is
that
also that the gift deed is fake.
Comparison, kindly have a look to my lord.
Yes, comparison is
The page, inner page 2,
in a page 2 of the impugned order.
impugned order.
Yes.
The two deeds, that is also fake one. Both the deed fake. The comparison,
Have you challenged that deed?
yes, my lord.
The other deed with which it is being compared. Have you challenged that deed?
No, I have not.
So how do you say it's fake? It's not challenged.
I have annexed. I also
Maybe you have annexed.
I raised objection, and that has not been
Raising
considered.
objection will not do. That is a registered instrument, sir.
And
that is a registered instrument.
Yes.
Merely by saying I am challenging will not help.
the another person who is not at all the owner of this land.
That is a different thing
Yes.
altogether. I am only on the application for handwriting LTI expert.
I shall satisfy you, your lordship, my lord. This matter be taken up for hearing. Yes, my lord.
Now I am taking up for hearing.
Only 2 or 3 days may be granted, my lord. I shall satisfy
Fine.
your lordship. Any date may be
What is
fixed
the
by that.
impugned cell deed? Where is your plaint? What is the miss case? Is the preemption application?
Yes, my lord.
Preemption application. You have said the entire proceeding is fake. That is your prayer. By false personification. It is for you to prove. It's by false personification.
Yes, but I have some documents, my lord, and I have annexed, my
So
lord.
without the, if it is by false personification, without appointment of a LTI expert, can it be proved? I'm asking you.
And
I'm asking you, can it be proved? Without appointment of LTI expert?
yes, my lord. LTA expert, the two fake deed. How it will be proved? Fake deed also.
Show me a admitted deed which you have produced with which you want examination.
89.
You are appearing for the opposite party.
Opposite parties, my lord. Yesterday, I have been instructed to appear.
You are also not ready.
No, no.
Ashok. The learned advocate appearing for the petitioner prays for
Seven.
Yes,
Seven
Mr.
order,
Das.
I am for the petitioner. Petitioner was challenging the order dated 7th October 2024 passed by the Civil Judge Junior Division in connection with petition. Petitioner filed an
Acceptance of commissioner's report, revision maintainable. That is the order.
yes.
Acceptance of commissioner's report, revision maintainable.
Right. Take.
Order 26, Rule 10 procedure to be an evidence in the suit. Commissioner was examined,
No, my lord.
was not examined. Commissioner was not examined.
Not again.
What are you saying, sir? Commissioner was examined. Kindly come to page, internal page 5 of the impugned order.
Order.
Just before concluding remark, last 3 lines. During cross-examination of the commissioner, the defendant failed to bring any contradictory.
Internal page 3 of the order, my lord, there is.
Yes, internal page 3 of the order.
Yes.
What does it say?
That is the, my lord, point, my lord, taken by this petitioner, my lord. Survey manual that no fixed points has been found by the commissioner.
Is there any fixed point? At the time of commission, did you indicate to the commissioner what were the fixed points? Show me that you have indicated to the, from the minutes of the commissioners, that you have indicated these are the fixed points as per the Moja map.
And not consulted, my lord, neither CS Moja map or RS Moja map that.
Nothing. Order 26, Rule 10, it will be an evidence in the suit. See the language of Order 26, Rule 10, Sub Rule 2. The report of the commissioner and the evidence, but not the evidence. Right to cross-examine, you have done that. Ashun, by this application under Article 227 of the Constitution.
Lord, for the petitioner, I prefer this revisional application against an impugned order dated 27/1/25, where the learned second civil judge Unit Division Parsas rejected the application under Order Rule 1, Order 1, Rule 20, my lord.
Order 1, Rule 10.
Order 1,
Where
Rule
is your application under Order 1, Rule 10?
My lord, it is on annexure C, page number 28.
Yes. You have prayed for substitution.
Yes, my lord. My lord, the application was wrongly captioned as Order 1, Rule 10.
So it's Order 22.
Order 22, my lord.
So when the plaintiff died?
My lord, the plaintiff died in the year
2020.
2020, my lord.
2020 you have stayed. 21st of February 2020 in the application, first paragraph. Sorry, second paragraph. And when have you taken this application, taken out this application?
My lord, it was filed on 13/12/24, my lord.
So abatement has set in. You have not paid for setting aside the abatement.
My lord, the applicants are the legal heir of the plaintiff, and they were unaware of the fact that the proceedings were.
So you have to pay for setting aside, explaining those reasons why you could not file within the time. What did the learned trial just say? Ashun. This application under Article 227 of the Constitution of India
My lord, in item number 9, my lord, I beg to appear on behalf of the petitioner.
Yes,
My lord, for personal difficulty, my lord, I am unable to come to court
Yes.
physically today.
appear virtually.
Yes, my lord.
You can appear virtually. You can do the
My dear
submission.
lord.
Yes.
I am a preemptee, my lord. I am a preemptee in a partition, in a preemption suit, my lord.
Yes.
The specific point raised in the appeal, my lord, that that with the short deposit, my lord, the preemption application has been filed. Keeping the application pending,
Show me, Mr. Betal, you have raised this point and how it was decided.
it has not been decided, my lord. Kindly have a look to my written objection page, my lord, 34.
Paragraph 25, page 9 of the impugned order. What is
It-
the
it- it-
consideration made in the deed? What is the consideration mentioned in the deed?
3 lakhs and odd.
Yes. Kindly
That
come
has been, yes, I have raised this.
5 of the
Out
order.
of my case is he has deposited the consideration out of time. That is why I filed an application before the appellate court. My lord will find page 34. Yes, my lord.
What was your case? That there was a short consideration.
Yes, short deposit.
Short deposit.
My lord will find in the application page 28.
Page
28.
No, show me that you have raised this point before the appellate court. Which paragraph?
Even in the suit code, even the trial code also. My lord, page 34, in my written statement, a written objection, para 10.
No, not in the written objection. Show me that you have raised at the time of
Yes,
hearing.
para 10, page 34, my lord. Page 34, para 10, in my written objection.
Mr. Betal, not in the written objection. You may have taken many points in your written objection. Show
Short
me your
deposit.
that
Short
point.
deposit point. Short deposit point, para 10. Short deposit point.
Mr. Betal, you are not understanding what is calling from the court.
Yes.
Show me from the trial court's judgment that you have raised this point and how the trial court or the appellate court has decided that.
Trial court and appellate court did not at all refer any issue on this aspect.
Kindly come
Only
to
said,
Mr. Betal, kindly come to paragraph 25 of the appellate court's judgment. Kindly
yes,
come.
my lord.
Yes, sir.
Yes, lord. Yes.
Yes,
It
please.
says, my lord, it appears from the certified copy of, I would refer that. I would refer, certainly, my lord, certified copy of the impugned deed number such and such, that the consideration amount involved in the said deed is rupees 3 lakhs and odd, and the respondent has deposited this sum. And my specific case, it has been deposited out of time. In the appeal court, I have filed an application without disposing of the application. Well, my application is at page, my lord will find page 44.
Page 44
is my application before the appellate court. Even in the trial court, I raised this point. This point was never decided by the trial court. Out of time, they had deposited.
When they have deposited? Tell me when they have deposited.
At least, my lord, after filing of 10 months, 10 months after.
Show me from your pleadings that you have stated that.
My lord, page 44, my lord, I have. Page 44.
Show me when they have deposited. What is your case? You have to make out
in their written objection, my lord, that application was kept by the order number 14, my lord. Order number 14 on 7th of May 2022. My application was kept for hearing. That application.
Mr. Betal, I am asking you, show me from your pleadings when they have deposited.
It is their written objection, it's page 48, which has been filed before the appellate court.
What is the date when they have deposited? I am asking you. Give me the date.
28 May 2019.
28 May 2019.
19.
Stated. Wherever stated.
It is from their objection in our against our application.
Show me which page.
Page 48.
Page 48.
48. That application has not been decided by the appellate court. It was kept pending and finally passed the order. And this one of pleadings is contrary to the judgment passed by the Lord in the case of Abdul Motin Mullik. It has to be accompanied with the consideration amount.
What is the parent judgment on this?
Barasadai Hospital.
Yes.
And my
The
lord,
advocate who did the commission work is also present in the courtroom. In Barasathai Hospital, the
My
learned
lord.
advocate who was appointed as a commissioner in that matter, Barasathai Hospital, he is present in court now.
I am unable to hear my lord clearly. My lord, sound is
Yes.
some breaking. My lord. And Abdul Motin is, my lord, specifically says my lord 6.3 has to be deposited with the application. And in the application, they admits, my lord, within 3 months, my lord, they are filing the application with the short deposit. He cannot take advantage because this time starts from the date when he filed the application.
This is your best point, Mr. Betal. Or you have other points?
At least for this stage of service, I can say this, my lord. For this stage of motion, my lord.
Mr. Betal, preemption is on the ground of which ground?
Course heresy.
Error.
And also, my lord.
So, is it your
also.
entire share was transferred?
Entire share has been transferred.
Ashun.
My lord is.
Here
my lord, what my lord is passing order, my lord.
Only hear the court. Full stop. This application under Article 227 of the Constitution of India is.
My lord's sound is off, my lord.
Sound is at the
off.
Of the pre.
Court is off.
3rd of 2024, passed by the learned Additional District Judge Ghatal District, Paschim Medinipur, in J. Miss Appeal number 1 of 2021, affirming the order dated 27th of January 2021, passed by the learned Civil Judge, Junior Division at Ghatal District, Paschim Medinipur, in J. Miss Case number 33 of 2018. First up, Mr. Betal, learned advocate appearing for the petitioner, submits that the issue involved in this submits that the entire share was transferred
with the demarcation, my lord, also.
Entire share was transferred, which is the subject matter. Now, which was the subject matter of the preemption application?
My lord, may I interrupt?
The issue involved in this application is the issue similar to the one which has been referred to a larger bench. A coordinate bench in CO 21 of 2019 in the case of Sajidul Khandokar versus Bhavani Bishwas by an order dated 29th of August 2019. Mr. Ghosh, reference is still pending.
Yes, my lord. Yes.
Yeah. Still pending.
Presided by Justice Bhattacharya, Justice Parthasarathy Sen, and another honorable judges of hearing this matter.
Kiola formulated an issue and referred the same and referred the same before the Honorable Chief Justice for constitution of a larger bench. The issue formulated by the coordinate bench runs thus, inverted comma, whether an application for preemption is maintainable under Section 8 of the West Bengal Land Reforms Act, 1955, in the event a Rayat transfers his/her entire her/his entire portion or share in a plot of land to a person other than a co-sharer. First up, since the issue is pending before the larger bench, CO number such and such is admitted. First up, petitioner is directed to serve a copy of this application upon the opposite parties by speed post with acknowledgement due, by registered speed post with acknowledgement due, and file an affidavit of service on the next date. There shall be an order of stay of operation of the judgment and order dated September 3, 2024, passed by the learned Additional District Judge Ghatal, District Paschim Medinipur, in J. Miss Appeal number 1 of 2021 till the end of June 2025 or until further orders, whichever is earlier. List this matter under the heading contested application in the monthly list of June 2021. Next.
Grateful, my lord.
May I please your lordship? Before your lordship goes into the facts, goes into the papers, I just want to indicate what are the facts, your lordship.
What is the impugned order?
Lordship, there are 8 impugned orders. The fact is the petitioner before your lordship is the father who has applied for the custody of a minor child. My wife, I had been divorced, and thereafter she passed away in April 2024. It was agreed in the divorce that all along since my wife was alive, I had paid my alimony and the custody was to be there with my wife. Having passed away, I came to know, I came in May 2024 and I applied for a custody before the trial court. The petition under section 12 was admitted, section 7 was admitted. Thereafter, I filed an interlocutory application seeking for interim custody. In the interim custody, there were certain defects. He makes certain error only while the trial court allows my application. He only puts a condition that I will only visit on a Sunday. I go back and file a modification because the order provides that my interim petition is allowed. In the interim petition, I sought for entire interim custody and other rights. Having said that, I apply for, since the bench was not sitting, I apply for a section 24 transfer. That's also pending in March. Now, the
section 24 before the
Barasat court, since the court, the learned judge court was vacant for the last 6 months, so I applied for a prestigious transfer. That's also pending in March. The travesty is that the petitioner has been continuously writing to the parents that allow me to meet, visit, speak. It's nothing happened. Now, kindly comes to the order first, your lordship, what I'm challenging.
Because serve and come back, otherwise.
I agree, I lordship. Kindly comes to 2 pages. I'll just show what's the trouble I have. Kindly comes to page 54 once.
54.
Yes. This is order number 4, dated 6 January 2023. There is an error in the order. It provides, having regard to the submission made, the prayer is allowed. Kindly marks this. We applied for a rectification because the order incorrectly records the submission. Now kindly comes to page 58.
Yes.
Page 58, it records a petition is filed by the petitioner for rectification of defects in the order. The typography is error kept in. Kindly see the middle paragraph. Petitioner's interim application is allowed. As an interim measure, petitioner shall meet daughter on the last sentence. Now kindly see my interim application prayer 48. Page 49. No. Yes. Having my interim application, kindly, your lordship has page 49. Yes.
49, yes.
Pass an urgent and immediate order granting interim custody of the minor child Vani Sonthalia to the petitioner during the pendency of the main suit. Order directing the opposite parties to allow the petitioner access visitation rights to the minor daughter. And order allowing the petitioner to take his record temporary custody. The learned trial judge, having allowed my application, puts an extra condition that I will only visit on a Sunday. Knowing fully well that I work, I am not stationed in India. My parents are stationed.
This is under challenge. You are affected by this.
Yes. This order and subsequent orders, because it's pending. I am filing a transfer. My emails are recorded. I am writing every day.
The learned advocate appearing for the petitioner submits
I'm here. Because I filed a 24 there.
Why the proceedings should be stayed? Let it happen because you have applied for the final custody.
Yes.
Lord 11, my lord, I have lodged caveat in this matter, my lord. I haven't received the copy. They have not given a copy.
They have not served them a copy.
Till now, not, my lord.
Caveat is there.
Caveat.
Why have you not served them a
Caveat
copy?
number was not there, but actually I called him.
My lord, just now,
I was
my lord,
calling
just
him.
I was in court number 11. I couldn't take up the
My
call.
lord,
I
I'm
should
serving
have
the copy. That's why I have called him, my lord, over phone.
You should have served him earlier,
Yes, my
not
lord.
today. Why have you not served him?
Beg your lordship. My lord, may I submit, my lord, kindly?
Yes. Mr. Mukherjee is leading you. Where is he?
My lord, he is in courtroom number 11, my lord. The matter is going on.
Yes.
My lord, I am the petitioner wife who was the defendant in the mat suit, my lord. The mat suit was filed in April 2019, your lordship.
Do you have an extra copy?
Yes, your lordship.
Give it to him. Yes.
My lord, on 22nd April 2019, the mat suit was filed against me. My lord, on 6th of August 2020, I have filed
What is the order under challenge?
My lord, the orders are two. 31st August 2023, the order was passed.
Yes.
And thereafter, your lordship, my enhancement petition and
31st
others,
of August, what order was passed?
the order was passed
Fixing the alimony.
fixing the alimony, your lordship. The quantum was wrongly calculated, your lordship,
Yes.
and that was not granted from the date of filing, your lordship.
That is the
That is
allegation.
the contention, your lordship.
So it should have been from the date of filing of the application, not from the date of the order.
Yes, your lordship.
So are they paying? Are they paying?
They are paying the maintenance as per the order, your lordship.
As per the order, since
Yes, your
when?
lordship. Since August, your lordship.
Since August 2023, they are paying.
Since September, your lordship, I beg you.
August, the order was passed.
Yes, your lordship.
So from September, because from the date of the order, it has to be from September.
Yes, your lordship.
So September 2023, they are paying.
Yes, your lordship.
Uh,
And my 36 months was gone, your lordship, from the date of filing, your lordship. That was 3 years before I have filed.
I appreciate that. So now what happened after this?
Thereafter, your lordship, I filed 151 application.
Yes.
In that, I have stated everything, your lordship. But that was not
stated that it is to be given effect from the date of filing.
Yes, your lordship. And also,
did you file that application under 151? What is the date of your filing that application under 151?
your lordship, that was filed on just a minute. That is page number 121, your lordship.
Give me the date only.
Yes, your lordship. Twenty-eighth of 11/2023, your lordship.
28/11
November 23, your lordship.
2023. Page
121, your lordship. Yeah.
No, 121 is the objection.
I beg your pardon, your lordship. That is the page number 110, your lordship. That was my application of under section 151.
So this is the only modification you want.
Your lordship,
from the
another
date of the
indulgence.
application.
Yes, your lordship. Another indulgence, your lordship.
And
when the quantum was fixed, at that point of time, the financial year of 1920 was considered, but not the financial year 2021 was considered.
So you also want
also
enhancement?
want enhancement to that effect, and thereafter I have filed one DLF annual report of 23-24. That was also rejected. That was not so taken into consideration by passing the last
Right.
article.
Awesome.
My lord, only one thing, my lord. My lord, kindly keeps it pending, my lord. My lord, we will come with some documents that we are paying since not before filing, before the filing of the suit also, my lord. We are paying it ourselves, my lord. We will produce all the accounts, what we are paying, my lord. Kindly, my lord, keeps it for some.
When this matter is taken up for hearing, Mr. Bhattacharjee, learned advocate appearing for the petitioner,
Interim order.
Madam,
of
you have
6
not
lakhs.
served.
Yes,
You are praying, you have not served the caveator,
my lord.
and you are
My
saying
lord,
interim.
My lord.
You know, list this matter
Obliged,
under the heading motion.
Well,
12, I beg to appear on behalf of the petitioner, my lord.
Yes.
my lord, the caveat, my lord, before my learned senior friend starts, my lord.
Not served.
Served, my copy served, my lord, but my learned instructing advocate served me today itself morning, my lord. If my lord kindly keeps it on Monday.
My lord, I'll take lordship's 2 minutes time. My lord, in this matter, my lord, defendant is the petitioner before your lordship. My lord, we, my lord, filed a section 10 application. There was a prior suit filed by my mother. It is a dispute between two brothers. Mother, my lord, allegedly gifted, my lord, the property, some portion, my lord, to my learned friend's client. Thereafter, my lord, filed a suit praying for cancellation.
You filed a suit for cancellation.
My mother.
Mother
Both
filed
of
a
us.
suit for cancellation.
Cancellation. That is the prior suit. Now, my lord, my learned friend has filed a suit, my lord, praying, seeking eviction against my client. Now, my lord,
of a licensee.
yes, because brother is now, my lord, has become licensee because of the mother. Now, my lord, the problem is, my lord, the learned judge has held, my lord, in the by the order impugned, since there is no, my lord, parties are not same and the issues are not same. But, my lord, I am covered by the. So, honorable, my lord, I know, my lord, your lordship's order is there, my lord. One order passed by your lordship went up to honorable Supreme Court, but that was a different, my lord, subject matter altogether. My lord, that was a suit for declaration of share, some portion of share. My lord, here, my lord, the declaration is cancellation of the
What
deed.
is the stage of both the suits?
My lord, almost same before the same court. My lord, even if your lordship kindly.
Consolidation.
Consolidation, lordship, my lord. My lord, my humble prayer is that only. My lord, before the same.
Issues are same.
Issues are, my lord, issues are akin because, my lord, in case, my lord.
Because suit for eviction of a licensee is dependent on the title.
Yes.
If
And
the title goes, your suit will.
And, my lord, these, my lord, two suits, my lord, if two independent decrees are passed, two independent decrees cannot survive, my lord, independent of each other.
One will become res judicata.
Yes. One will become resident. That is the exact, my lord, test, my lord, applied in Honorable Supreme Court in 2005 judgment as well as, my lord, the subsequent judgments. Now, my lord, my humble submission is that, my lord, lordship may kindly.
I think I have distinguished that in one of my judgments.
Another question.
But that was a different thing altogether. I think
altogether,
probate was there.
Yes,
Probate
probate
and
was there. Yes.
partition.
Partition. My lord, on that score, your lordship, my lord, distinguished.
What happened in the Supreme Court?
Upheld. Your lordship's order was upheld.
No difficulty? Or you want time?
So if my lord decides the analogous
Consolidation. So both the suits are at the same stage.
Before the, my lord, this suit, my lord, lordship kindly considers, my lord.
Both are in. I am told that both are in peremptory hearing stage.
Yes. My lord, here, my lord, PW1's further examination is going on in, my lord, the eviction suit.
Where have you stated? Have you stated anywhere?
No, my lord, it would appear from the order sheet, my lord. 23rd, impugned order, lordship, 23rd of December.
Impugned order.
Yes, the last, my lord, line. 28th January, my lord, was, my lord, that was the date fixed, my lord.
First paragraph, last line.
My lord, the ordering portion, if your lordship kindly
Ordering
see.
portion.
Yes,
No, ordering portion, this is for further examination of PW1.
yes.
This is in which suit?
This is, my lord, in the subsequent suit for eviction.
That is his suit.
My suit.
And what is in your suit?
My suit is also at the same stage, my lord.
Where do I know? How do I know that?
My lord, I have probably, my lord, if
Have
I'm
you
not-
stated anywhere?
No, my lord, in my application, my lord, may I just lordship kindly grant me a second, my lord. দেখতো ওখানে suit এর নাম্বারটা put কর। Lord, I find, my lord, it is written, my lord, in my application that the, my lord,
You have stated that where?
my lord, in my application,
Application for stay or civil division application?
application for stay, lordship. Your lordship kindly sees. Paragraph 5, my lord, onwards, my lord,
Page.
page 86.
86.
Lord, just before that, my lord, the order of injunction was quoted, my lord, at the top of the page. And then, my lord, paragraph 5. I've stated this is the prior suit, but, my lord, the stage, my lord, I do not find, my lord, here.
Both are at the peremptory hearing stage.
My lord, I'm told that, my lord,
Your suit is the earlier one.
my suit is the earlier one. My lord, my suit number is, my lord, title suit number 459
of 2020. Both
and
the same court.
both before the same court, their number
Who
is
executed the gift deed?
mother. My mother.
Mother.
My mother.
And
And mother was,
you have annexed your plaint.
That is at page 13.
page 13.
Mother filed the suit.
Mother filed the suit.
Thereafter, mother passed away.
No, mother is living.
Mother is
Yes.
He passed away.
Passed away.
Passed away.
আমরা substituted.
So now who has been substituted in this suit?
Brother. I'm told that the brothers have been substituted in this.
Brothers already substituted.
Brothers or brother?
Brother.
Brothers, my lord, there are brothers.
There are others.
But initially there was an agreement that, my lord, his client will, my lord, take a loan and he will pay the EMI. And the EMI will be adjusted, and on that basis, my lord, mother gifted the property on the basis of the terms and conditions set out in the agreement. Now, my lord, his, my lord, client failed to pay the EMI. Then, my lord, the problem cropped up because it was a mutual understanding between the parties.
This application under Article 227 of Yes, call the list.
Martin.
The plaintiff, my lord, is the petitioner before your lordship in a suit for partition and injunction. A revisional application, my lord, is directed against an order whereby, my lord, recalling of, my lord, witness has been allowed for the second time. But I say this order is barred by res judicata. Kindly, my lord, comes to the first order, page 51. আমাকে পেজটা ঠিক করে বল, নতুন পেজ চেঞ্জ। I'm sorry, my lord. 53. আচ্ছা 53. My lord, kindly comes to page 53.
50?
53, 53.
Yes.
This was for the first time on 8th of January, my lord, order number 56. Your lordship is at order number 56.
Yes.
Today is fixed for further evidence with a type copy, my lord. The original is just before that. Parties filed separate hazira. Learned advocate for the defense stating that they are not willing to adduce further evidence. Hence, evidence is closed on consent. Fixed for argument. They, my lord, thereafter come up with an application that no, mistakenly we have done that. We want to recall. Lord, the court considers that. Court allows it. Lord, that order, your lordship would kindly get at page just 54, my lord, just after that. Order number 58, dated 10th of February 2021.
Yes, page 54. Yes.
Lord, now, my lord, kindly comes to the impugned order.
No, what happened after this?
My lord?
What happened after he was granted liberty
Yes, he was
to adduce
granted liberty to
evidence?
adduce evidence. He again felt that he was not required to, my lord, adduce evidence. He kept silent. He did nothing. Now, my lord,
So he
kindly
did not
comes.
pay the cost also.
Yes, he paid the cost. He paid that 300 rupees cost, but did nothing. Thereafter, my lord, kindly comes to the impugned order.
Again, it was closed. No.
Yes, I'm sorry. Kindly, my lord, comes to page 56, order number 63.
Evidence closed.
23rd of November 2021. After waiting for so long, 58, 59, 60, 61, 62, thereafter 63. Nothing happened. It's closed. Now, my lord, he files the impugned application. That's at page 57. With, my lord, no ground. Just as a matter of right, he comes to court that mistakenly I have done this. Kindly permit me to adduce evidence. The court, my lord, by the impugned order allows this.
What happened after this? Because 7th of November, it was fixed for evidence. What happened after this?
Lord, 23rd of November 2021, your lordship is looking into.
No. The impugned order, the date was fixed on 7th of November 2024 for further evidence, subject to payment of cost. What happened?
Lord, because the revisional application is pending, 12th March has been fixed as the next date.
They have paid the cost.
They have not paid the cost. Lord, I understand, Lord, the cost should have been, Lord, I do not.
The Kormokar, it will delay your suit only. Because
fixed for argument.
I have to stay this. If I admit your petition, I have to stay these proceedings. Otherwise, let them depose.
But again, the same thing will go on.
No, that the in default argument that was there. I will only record that if they fail.
Kindly sees 2021 January.
Mr. Kormokar, I appreciate your submission. But if I entertain this, I have to stay, the suit will remain stayed.
Lord, if I may pray for only one thing. If I may
Part
pray
of
for
March, on that day, if they do not do, closed.
Closed. Final. Very.
Are you sure that 3rd of March? Take instructions on that.
3rd of March.
Or 12th of March?
12th of March.
For argument.
For argument.
So on that date, if they do not depose, it will. So what happened on 7th of November?
7th of November, my lord, because we
They
filed.
came to adduce evidence, but at your instance
Yes,
it was,
it was done.
at your instance it was,
Because the visual application was pending.
yes.
My lord, they had tendered this payment, but we did not accept. My lord, that's what
So
our
there was
instruction
bona
was.
fide on their part.
Yes, they had tendered. They has tendered. But my lord, kindly fixes that date as full and final. If they do not come, my lord, it will be closed, argument will commence.
This application under Article 227 of the Constitution of India is at the instance of the
Expeditious disposal.
Expeditious disposal of what?
Matrimonial suit. Filed in the year.
Matrimonial suit. What is the stage of the suit?
Issue has been.
Reconciliation.
Yes, issue has.
What happened?
Reconciliation
Reconciliation. What happened?
failed. So for my instruction that has been failed. Issue
You
has
are for the
petitioner.
husband.
Yes,
Alimony.
Alimony they have till they have not praying, my lord. If my lord desire, my lord, I can pray. Till they have not preferred that application, my lord.
This application under Article 227 of the Constitution of India is at the instance of the husband praying for a direction upon the learned additional district judge Chandanagar district Hooghly to dispose of matrimonial suit number 430 of 2023. Issues have been framed.
Yes, my lord. Issue has been framed last day, my lord. That is
The learned advocate appearing for the party, learned
my
advocate
lord.
appearing for the petitioner submits that
29/11/2024.
issues have been framed as would be submits that the issues have been framed and 20th February 2025 was fixed for reconciliation and in default for peremptory hearing. First up, the learned advocate appearing for the petitioner further submits that the reconciliation which was fixed on 20th of February 2025 however failed. First up, he further submits that no order directing the petitioner to pay any alimony has been passed by the learned trial judge in the said matrimonial suit. First up, in the light of the aforesaid submissions made by the learned advocate for the petitioner, matrimonial suit number, the learned civil judge, the learned additional district judge Chandanagar is requested to dispose of the matrimonial suit number 430 of 2023 as expeditiously as possible if the petitioner is not a defaulter in payment of any maintenance that may have been directed by the learned trial judge or before any other or by any other forum. The above observations, PO number such and such times.
Time.
Do not know because maintenance, how much time, let it be there. Otherwise, service, let them come. Yes, next.
15, my lord, Mr. Haldar was appearing for the petitioner, my lord. Due to his personal illness, he
Which
could not.
Mr. Haldar?
Mr. Pankaj Haldar, my lord. He could not come to court today, my lord. So I am seeking only for not today, my lord. I am humbly praying.
The learned advocate appearing for the petitioner prays for it is however made clear that pendency of this
I appear on behalf of the caveator, madam.
Lordship, I am for the petitioner. The counsel for the petitioner is very sick. I'm praying for not today, my lord.
have you served upon him?
Yes, my lord.
Lordship, I am appearing for the caveator, Lordship.
We have served the
You have
copy.
got a copy?
Yes. Lordship, may kindly see. I do not know if the revisional application, it may be maintainable, but they may not be entitled to any reliefs. Because what they have done, they have challenged the order of modification without challenging the parent order.
An accommodation has been sought for by the learned advocate for the petitioner.
There should not be any, they should not be allowed.
Pendency of this application shall not preclude the
petitioner. Here, my lord, the caveat has been lodged. And my lord, service is not effected. My lord, we will complete that by today only. Can it be taken up on Monday, my lords?
what is the main matter? What is the main
My
matter?
lord,
Let me see whether service is
my lord, my
necessary or not.
application under section 7(1) has been rejected on the ground that I have came after 1 month of service of summons. My lords, here my specific case is that no summons has been served upon me, and my lords, I have appeared in the suit after obtaining my lords information slip. My lords, record of the case reflects the summons cannot be served upon me either through personal service or through court bail. So, my lords, plaintiff's application under Order 5, Rule 20, substitute service has been allowed, and my lords, paper copy of application has been made.
Finding is summons was served.
Yes, my lord, that on that date, my lord, substituted service has been made. My lord's, record of the case, my lord, reflects that personal service or court bailiff service has not been affected upon. Personal service, summons to personal service or through my lord court bailiff has not been served upon me.
Then you don't appear in the suit.
My lord,
Let
it has
the
been
suit ex-parte decree be passed.
My lord, it has been
You
my lord, it has
file an application under order.
my lord, it has been
Take those points there.
my lord, it has been fixed on the Ex-parte board. My lord, thereafter I came. Thereafter I
Has to
came,
be.
my lord, and I have
So
said.
let the ex-parte decree be passed. Thereafter, you file an application under Order 9, Rule 13.
My lord, thereafter.
Satisfy the court that no summons was served.
My lord, there I have said, my lord, that I have came to know of the suit from the information slip, and I have annexed
Where
the
have you
information.
said that?
Yes, my
In the application under section 7(1?
Yes.
You have filed the application under section 7(1.
Yes.
Show me that.
My lord, kindly comes to my lord, page 34 once.
34, yes.
My lord, 33 first, my lord, 33. This is the my lord information slip. And thereafter, my lord, 34. This is my application, my lord. Kindly see paragraph 2 and 3 and 4.
No. Where is your application under section 7(1? Show me that.
37, page number 37.
Where have you stated that no summons was served upon you in section 7(1?
My lord, in my lord,
7(1).
My lord,
Where have you stated that no summons was served upon
my
you?
lord, in the application, my lord, when the suit has been fixed on the Ex-parte board, thereafter, my lord, I came up with this application that has been allowed, and the suit is taken up from the my lord Ex-parte board, and thereafter, my lord, I filed the application under section 7 and within, my lord, one month from the date of appearance. Section 7(1)(b) also said, my lord, if the summons is not served.
Sir, I'm asking you, show me from your application under section 7(1) that you have not received any summons. And where from you have come to know? Show from section 7(1).
My lord, this application has been allowed. That is why, my lord, I have.
Which application has been allowed? 7(1).
Page 34 for my lord taking up.
I'm not on page 34, sir. Kindly come to page 37. I'm at page 37.
My lord, I have paragraph 1, my lord, I have said, I have came up.
I'm asking you, how did you come to know of the suit? Where have you stated that summons was not served? You may appear after 3 years. Where is your positive statement that you have no summons has been served upon you?
Because I have already filed an application for taking up the suit from the Ex-parte board and to my lord permit me to contest the suit. There I have said, my lord, that summon has not been served upon me. Page number 34 is that application.
Where is the order allowing this ex-parte hearing?
Yes. My lords, that has been annexed.
Show me that. You are taking advantage of that order.
My lords, page 49.
Purely a non-speaking order. Nothing has been said.
My lords, that
I've seen that order.
my lords, that has been allowed.
Yes, yes, may have been allowed.
And my lords, within
May have been allowed to give you an opportunity to contest. And you are taking that advantage in 7-1.
my lords,
227 suo motu power can be exercised against any order. If you want,
my lords,
I will ask you to show cause as to why this order should not be set aside in your revision
my lords,
application.
plaintiff has not, my lords, filed any written objection.
Suo motu power, plaintiff may not have challenged. So you have been granted an opportunity to contest. You are taking advantage of that fact in 7-1.
My lords, I have not said the
Nothing has been said that no summons has been served. Only ex-parte hearing was set aside.
my lords, substituted service of summons cannot be, my lord, taken that on that day I have the date of knowledge of the proceedings. My lord. My lords, I will not be able to contest the suit. It may be my bona
Will
fide.
not be 7-1 gone.
My lords,
So even if you appear, right is very limited.
my lords,
Only you can cross-examine.
my lords, it is my bona fide as well. My lords, why?
Law is such.
My lords,
Defense.
law is specific that if the summon is
All
not
right.
served upon me, my lord, my lords, kindly not dismiss.
The learned
My lords, kindly not
necessity to serve. If I want their presence, then service.
my lords, if six.
If it is dismissed, they will not be prejudiced.
My lords, here,
Even if they come, I will.
my lords, here it is, my lord, my bona fide, my lords.
The
My lords,
learned
here it is, my-
advocate appearing for the petitioner.
Lordship, in this matter, I'm appearing for the opposite party, praying,
The caveat was being lodged, my lord, I have served.
Yes.
praying for not this week, Your Lordship, because the opposite party is a partnership firm run by two partners. So the wakalatnama could not be obtained, Your Lordship. If you give us a week's time, we would come back, Your Lordship.
My lord, only one thing, my lord, since my lord, it will be a non-compliance of 7-2, then my lord, my defense may be strike out. My lord, may I just show before your lordship what is the
Lordship,
case?
a week's time, Lordship.
Yes. You are the defendant.
I am the defendant. If your lordship takes up the plaint case is that 125 is the monthly rent. 125 is the monthly rent. If your lordship takes up not page 16, 16 is not the plaint starts. Kindly takes up page 17, paragraph 2. But the rate of rent is being pleaded, my lord, last bottom of paragraph to 125. Has your lordship got it, my lord?
Yes, yes.
Kindly turns over the page. What is the period of default? Page 18, 5.1, Roman 1, from January 2012. So, my lord, 125, and the period of default is from January 2012. This is, my lord, the pleading in the plaint. Kindly takes up my 7.1 application. My lord, at page 23. Page 23. 17.1 application. My lord, what I stated at paragraph 3 at page 24. I stated, my lord, that no, the rate of rent is not 125, it is 184, my lord, it is 217. Breakup is given. 184 is for, my lord, rate of rent, proportionate share of municipal tax is 15, and, my lord, the municipal charge is, my lord, 18. So I stated that it is 217. And the period of default, I admitted entirety of the rent, including, my lord, admitted area of rent, including, my lord, the prior period of default that has been deposited under 7.1.
Yes.
Now, my lord, in 7.2 application, what is my lord, contention that the lord, rate of rent is not as pleaded in the plaint? I relied upon the rent receipt. Kindly see, my lord, the rent receipt once.
No,
That
what
is-
happened? What did the learned trial judge?
So the learned trial judge says no. As per the West Bengal Premises Tenancy Act under Section 5, I ought to have give the municipal tax proportionate share, which has not been pleaded in plaint, the default or the rate. And on the basis of that score, he said entirety of his deposit that I have made under 7.1 is bad. With not 7.1 deposit, I shall show before your lordship, the landlord has taken the amount by filing an application that I allow me to withdraw that amount, which has been paid under 7.1. Kindly now see the impugned order once.
No, Mr. Mukherjee, kindly come to your application once.
7.1. Yes.
There you have stated that the breakup
Yes.
is 184 is the rent,
Yes.
15 is the proportionate share of tax,
Municipal tax.
and so you have agreed that
Yes.
you are liable to pay proportionate share of
Yes,
municipal
I
tax.
have paid. That is, my lord, the last paid rent. Rent receipt I have annexed. Page 64 of my lord's brief.
Yes.
Kindly takes up, my lord, once page 64. This is December 2011, the last rent receipt.
Yes.
From January 2012 is the period starts. My lord,
Yes.
kindly see the three heads. 184, proportionate share of municipal.
So what is the rate of rent the learned trial judge has arrived at?
My lord, the learned trial judge by Suomoto said that would have been, my lord, kindly see, my lord, for 150, 184 commercial tax, so it's coming 276. My lord, at the page, the second page of the order impugned, prior to the ordering portion, last two line, 276. It's a figure, my lord, which neither has been, my lord, claimed by the plaintiff in his plaint, nor supported by, my lord, the last paid rent receipts.
Lekin premises tenancy একটা দিন তো। Premises tenancy একটা দিন তো। Premises tenancy একটা।
7.2 objection কিছু।
The other side is giving time for us. You বলে যাচ্ছেন for your own thing, that is not done. ওরাও করি দাদা, তুই তো করেনি। পাখাগুলো মার।
So according to you, the last rent paid at the last rate, that would be the only relevant.
And, my lord, the pleading in the plaint. Plaint, my lord, case is restricted that I am not the rate of rent is 125. I himself, my lord, relying upon the last paid rent receipt, stated that these are the figures.
So plaintiff has claimed a lesser amount.
Lesser amount.
how this can, today my learned friend has difficulty. I am not, but if non-compliance of 7-2, my lord knows the rigors as on today. After Chamaria, I cannot even, seek for any defense.
Lordship, a week's time, Lordship. Let us come
What is
back.
the next, what
But
is
my
the
lord,
time limit within which you have to pay?
Today is the last date.
Today is
one
last-
month. 1 month. That's why my learned friend
has to be
otherwise,
extended.
I will be remediless. That's why.
Because if no stay is granted, then
Then by defense
Ashok.
goes.
The learned
be different. May I take your lordship?
It's between the same parties, different shop.
Different Not cubicle, not shop.
Rather cubicle.
What was the rent in the plaint?
Yes, plaint is 250.
Plainted rate 250. Default since?
Default since my lord same.
Default
January
January 2012. Acha, our last.
My lord, may I give the page number of rent receipt?
Page 36. Page 36 is the last rent receipt, 1st of December 2011. What is the rate? Total amount?
My lord, according to my lord, last rent paid is
356.
389.
389. ঠিক আছে? Our computed is in excess of that.
No, my lord, the total, my lord, I am sorry, my lord, the total rent as per me is, my lord, page 389 হচ্ছে কি? 389, my lord, I am sorry. 389. Yes.
And what is the amount computed by the learned trial judge?
Trial judge, my lord, has computed as, my lord, 497.
497. ওটা বোধহয় বলিনি, বলেছি excess of the
Excess,
amount
yes, yes.
computed. Today is the last date.
Yes. Last paid rent. No, my lord. Yes, 2 days. Same MP, my lord, same MP.
Today is the last date.
আমি চর্চা শুনতে পাচ্ছি না আপনারা বলছেন।
Same order next. Yes, call the list.
20. Yes, Your Lordship, on for 20, I am on behalf of the petitioner.
Yes.
Your Lordship, the petitioner filed a suit for partition and cancellation of deed for permanent injection on 8/12/2010 before the learned civil judge, senior division 7 court at
What do
Alipur.
you want?
Lordship, expeditious disposal.
Expeditious disposal of a suit.
Yes, Your
What is
Lordship.
the stage of the suit?
Your Lordship, the last order dated 21/1/2025 and therefore from 14 years, 5 months and
What
13
is the
days.
stage, madam, of the suit? I want to know the stage.
Lordship, the stage is that an amended petition was filed by the petitioner on the last occasion.
Amended petition or amended plaint?
Amended plaint was filed by the petitioner on the last occasion and therefore no progress has been observed since 14 years.
Why amended plaint was directed to be served through post? They have not appeared.
Your Lordship, the inheritance.
Service complete.
Yes, Your Lordship.
Written statement filed.
Yes, Your Lordship.
Issues framed. You have filed amended plaint, so they have to file additional written statement. Madam, come at 2 after taking instructions. What is the stage of the suit? 2 PM. Rahul.
Okay, Your Lordship.
Yes,
Obliged.
call the fixed matter.
Number 1, fixed matter.
Yes, Mr. Banerjee.
Better hands.
No better hands. But I'm sorry such a situation has arisen, but I know too little about it, but I've persuaded them to not give an apology. They are just typing it out. I'll just show it to your lordship.
Mr. Kaur, are you satisfied with that?
No, I have not showed it to him. I've just seen it. It's been typed on a phone. I'm just waiting for it to be not given to. There's no network over there.
But there has to be a sincere apology. It's not apology for the sake of.
Mr. Bachawat is here. I
This-
think it has to
this
be.
can happen to
all
my
I can
learned
say-
friend also.
No,
Tomorrow it can happen to my learned
It's
friend. It
no
can
point
happen to
being-
me.
Mr. Kaur, now since Mr. Bachawat is here, so
I'll take care of the
expect that it will be a sincere apology.
I'll take care of that. I've also had a word with No. I've had a word. I'm just waiting for that type. They were typing it out on the phone.
Because Mr. Kaur has to look at that. Because
Yes, I know. That's why I said type it out. It's no point saying things orally. It'll create a confusion. Just type it out. So they've typed it, unfortunately, on a phone. But I'll show it to you and learn it, right? And if there's any change he wants, again, I'll try and persuade it. This shouldn't have gone out of hand. The way it is, it leaves a bad taste in the mouth.
because after all, the
The way it's
parties may be fighting
Yes.
in the court in whatever manner they want, but the lawyers should not be.
I'm personally interested to make sure there's no embarrassment to the other side. I'll take care of it. I'll take care of it.
Lord, let me have a look at.
Yes, yes, that is.
And Lord, this is, must be an undertaking given to the, in the form of an affidavit.
ঠিক বলছো? এই শোনো, just যাচ্ছে না, একবার দেখে নাও জয়দীপ দা, I'll show it to the. Said, print করিয়ে নাও, একবার দেখে নাও, if there's anything else you want.
Yes, this is.
But, this is a conditional apology.
চাও বলো, I said, না,
It
you
has
asked
to
for.
be an unconditional apology.
No, you tell me
Just-
what
just
change
give
you
it.
want in it.
Mr. Kaur,
Can
Mr.
I
Bachchat
handle-
says if you want any modification, he can.
But I can show it to your lordship. If your lordship wants to quick look and suggest anything.
Mr. Bachchat,
I have no-
because
No,
they
I
have
know.
to be satisfied, otherwise
I
if
know,
they are.
I know.
Do you think that this is an
I
apology?
have not even seen it
I'll
properly.
leave it to you. Just read it and
Praise for
tell
an
me that this is an
apology,
apology.
praying for an apology, apologizes.
For attacking the lawyers.
Senior and for her daughter have felt insulted in any way.
Accent, please. Just let me comment.
একটা বলে দাও না যে ভুল হয়েছে।
বলো না, বলো
ভুল
কোনটা?
হয়েছে।
তিনটে জিনিস ধরে তো
I'll
বলেছে।
never do it again. এই একটা এইটুকু বলো যে ভুল
Never
হয়েছে।
do it again. আবার কি apology
মানে-
তোমার দরকার নেই
না
বলছে।
না apology তো চাই,
তাহলে-
but apology in the sense that entire
But
apology.
can I suggest something? But can I suggest something? But I'll give it to my learned friend. He can make modifications to this. He feels it's conditional, but I don't think so. But not if my learned friend.
So the language can be couched in a
That's what I'm
different
saying.
form if
He
according.
can. Not I have no difficulty. Not I'll just show your lordship. Not I've tried to make it. Not tried to ensure that. Not. It's been difficult as it is not to get this done. Your lordship knows not how these things are. But I'm personally interested to make sure, my lord, that these things don't happen.
His integrity is challenged. The professional ethics is challenged. She says that he has advised her. Where are those things?
So modified to some extent what Mr.
Let him not suggest it. I'll just forward this to him.
Suggest
It's
that,
not. it's not
Mr. Kaur, do you
connected
want
here.
to show it to Mr. Bandopadhyay?
Yes,
But I think that would be the best. Not if required, I'll sit with him once. Not I'll sit with him once and we can sort it out. No difficulty. But if he's there online,
He's online, but in this manner
Okay,
it cannot
can't
be
be
shown. So you can send it or.
I will.
I'll
If
not-
Mr. Kaur is there, he
I'll
can
send it
talk
to
to
him.
speak to Mr. Bandopadhyay.
Yeah.
2 PM or what do you want? Because otherwise the matter will be getting dragged. That is the.
PM, Lord, I'm supposed to be in Alipur court. But this is something which is more important. That's the only problem.
Yes, that's the only thing, because the other part is that because I have said that today, because my judgment is otherwise ready.
Lord, would your lordship give me one indulgence? I'm told that by 1:30 I will know whether I have to go to Alipur or not. I could not come and not inform my learned friend and your lordship's court officer if I can be here at 2. Not otherwise, I'm in your lordship's hand. Not, and in the meantime, Lord, I'll send this
Mr.
to him.
Bachchat, what is
If
that?
he can
Is
suggest
this-
a change.
Is the only modification. You can suggest that Mr. Banerjee may be here.
Correct.
Mr. Banerjee may be here, otherwise
But,
this.
Please don't trouble him. Not, I'm
No, not Mr. Bandopadhyay.
Oh, I see.
That is why I have
Yes,
couched
yes.
two different expressions,
sorry.
Bandopadhyay and
I'm sorry.
Banerjee.
I'm
Your
sorry.
junior,
I'm sorry.
your junior, Mr. Bandopadhyay is there. That is why I have consciously used the surname as Banerjee.
Very well. Not this can be discussed. The only thing is, not if I leave at 1:30, I won't have scope for discussion with Mr. Kaur. আর কিছুই না।
না, ওটা এখন পাঠিয়ে দাও।
এক্ষুনি পাঠাও না বাবা, একটু পাঠাও না।
পাঠিয়ে দাও।
আমায় কিংবা পাঠিয়ে দাও।
So there is still 10-15 minutes left. In
Yes.
the meantime, if you can,
But if
you
we
can
can
come
come,
before 1:15
we'll come-
also.
we
So
will come.
passing it over for the moment.
Keep
We'll
it at
come
2
back.
o'clock.
If not at 1:15 or 1:20, it will be at 2 o'clock.
Let me also
With
show
that
it to Mr.
understanding.
Bandopadhyay, because Lord, after all, Lord,
Banerjee,
it touches upon his integrity, his reputation, his good.
No, he has to be consulted.
Therefore,
He
I
has to be.
have to-
I think Mr. Bachchat will also appreciate that, because this may happen to any lawyer at any point of time. This should not have happened.
My lord,
And the
Lord, I'll
client
tell you,
on
Lord.
the other
Lord,
side
Lord.
should not have the right to even criticize. What happens in court is happens in court. He has the discretion, and an advocate has the discretion to place the case the way he likes. So therefore, Lord, there shouldn't be any criticism of.
I think since Mr. Bachchat is now here and he has taken charge of that, I think it will be resolved. I hope that it will be resolved. So if both of you can come just prior to the rising, it can be done.
Kindly keep it at 2. We will try to come by because this has to be
Mr.
typed.
Bachwat leaves, Mr. Kaur kindly consider if he leaves,
No,
there may
Mr.
be difficulty.
Banerjee is there. Before he leaves, we will finalize that.
Mr. Kaur, if that can be done prior to that, try. So then it will be, you can have a talk with Mr. Bandopadhyay with regard to this also. Yes,
I'll have to
call the next matter.
It just 21.
Twenty-one and 22 are similar issues, you know, 21, Mr. Basu. 22. This is a normal matter. I mean,
Normal order, hotly contested matter, Mr. Basu, as it appears. From the volume of the revision application, 3 volumes of civil revision application.
My lord's creation. This is my lord's creation. Now, if in the revisional application, plaint is not annexed, court has to say, why you are not annexed the plaint? Is it unknown to my lord?
Civil revision application.
What do I have learned? Total up to affidavit 10 pages.
Yes.
And now courts asking for why you are not annexed. This is a specific query from the court.
Very difficult to handle also, Mr.
Difficult to handle. When this was served to my learned junior, I was in Delhi at that relevant point of time. He informed me there are 3 volumes, big volumes. How can I send it on post? No, not.
And Mr. Basu is responsible for the building, sinking of this building.
Whatever bad thing here, I am no doubt about it.
Yes, Mr. Basu. What is this matter?
But, can you see the order?
Which order? Impugned order or the last order? No, what is this matter? This says he does not want to file any affidavit in opposition. You want to file supplement. What is the impugned order? What is the order under challenge?
It is mentioned for extension of interim order.
We don't receive any notice.
Extension of interim order. What is the impugned order?
Impugned order, my lord, point is very simple. Under section 14 of the SARFACI Act, whether the magistrate can pass twice an order because after passing of the main order, he became functus officio.
Any SARFACI application is pending.
It is
after DRT.
All
order of the DRT is under challenge.
Yes, the order of the DRT is under challenge.
What is the order of the DRT which is under challenge? Which page?
When it starts from the volume 1, page 1.
Page 1.
Page 1. It's a rather longish order.
Can we extend the interim order? Let us read another day.
Yes, let Mr. Basu come on Monday or Tuesday. Till Wednesday, my client will not do anything. This is my clear statement.
Till Wednesday?
Monday or Tuesday or Wednesday, let Mr. Basu make himself ready. Let him make the argument. I want the matter to be finished. Piecemeal interim order, this really hampers my client's interest.
হ্যাম্পার না হলে কেন দেবেন?
সেই জন্য তো বলবো। And my lord, the due is.
What is the challenge to the order under section 14?
Challenge is, my lord,
Police help.
Police help challenge the authority under the act passed an order. According to the law, according to the judgments of your lordship's court, the other courts, he became functus officio. If he pass a second order on the same application.
What is the second order? First order was directing that possession to be.
Yes. There, my lord, our contention is the recording which is required under the law has not been made. Satisfaction of the authorities has to be there. That is not there. This is maybe secondary point. First point, whether can he pass a second order, how when he become factus officio, unless there is specific provision under the statute.
So, how that order has been, that point has been dealt with by the appellate tribunal? Show me that.
This is clearly on 151. Here correction. Here correction. One person was.
No. Your lordship kindly come to page 6, paragraph 14. It starts. Paragraph 14.
Paragraph 14 starts with section 14.
Yes. Whether it is a functus officio or not. The same point was raised.
My lord, schedules the order.
Now your lordship kindly come to
19 November 2024, passed by Justice.
now your lordship.
19th November.
Your lordship kindly see this impugned order first.
No.
Page 17,
Before that,
page
can
10.
you see this order? 19 November order, my lord, is there.
Yes. 19 November order.
Can you produce that order?
Yes,
Get the point. Paragraph 2.
I'm at paragraph 2.
I know. Probably on the paragraph. This is the point. My lord was asking for the point.
How much time both of you will take?
Depends upon who my lord will give time. My lord slot has to be looked into. Slot.
Now, my lord, before your lordship fixes the time. My lord, before your lordship fixes the time, your lordship.
Because Mr. Basu and Mr. Chatterjee, only difficulty is that this cannot be heard at the motion stage. Because
No, it was not in the motion stage.
But now it's appearing in the
Now
motion.
it is appearing. Why it is appearing? It was in the hearing stage.
So I'm
Use the other
directing
way.
this matter to appear under the heading contested application.
For extension of interim. Extension of interim order, it was mentioned.
Extension of interim order, it was mentioned.
And without informing us. Yesterday at the late evening, I have seen it. No, nothing.
So I'm extending the interim order. I'm directing this matter to appear in the monthly list of April as contested application.
No, my lord. No, my lord.
It will take some time to decide.
There are dues up to the tune of 4 crores, public money. And they are enjoying the property for last 2 years.
Strategy because the
Not payment of
order,
not a single penny.
I appreciate that, but the interim order is subsisting. So I'm extending because this is to be hard substantial. So it will take time. Otherwise, motions are to be given. I'm fixing a date, contested application.
Prior to that, if your lordship kindly have a glance to paragraph 17, 18 of the impugned order. How
But Mr. Chatterjee, a coordinate bench applied its mind, passed an interim order, being satisfied, recording some kind of finding.
This has not been tested. No recording has been made regarding testing of this. Paragraph 17, 18 and all this. Yes.
But Mr. Chatterjee, I've seen the order, but coordinate bench has passed an interim order.
Yes, your lordship.
So I will hear both of you.
Your lordship kindly see. Here the coordinate says whether this is a functus officio or not. Correct. Now your lordship kindly see. It is not functus officio. That answer has been given. That is not indicated in the order dated 19. That these finding of the single judge, single bench or the DRAT is not correct. Privacy not correct. Nothing.
But that order was passed in your presence.
Maybe.
So that order was passed in your presence, and those prima facie findings, Mr. Chatterjee, is still there, not interfered with by any other.
Your lordship kindly see what the privacy findings. Considering the privacy case and balance of convenience, I direct the opposite party should not take any further steps till the matter next date hearing.
So if further steps are taken, the application will become infructuous. So the coordinate
they
bench
will not make any payment. They will enjoy the property. Government money will be at stake. If this is the
what is the stage of the main surface application? This is 14.
This is 14.
This is 14. What is the stage of the main surface application?
It is pleadings have been completed. Oh, the surface application moved by them.
Yes.
No steps has been taken by them thereafter. It is pending. And they are taking the time before the service tribunal that This matter is pending before the Honorable High Court.
Yes. When do you want?
3 days suits my lord slot fast, then our time. My lord slot has to be looked fast.
Slot is up to you. So if all of you want the hearing matter to be given preference, then
No, your lord,
Not regular visitor here. I will be told.
maybe
Mr. Chatterjee appears in all courts. Don't say that.
Of course, not regular visitor in civil revision.
Maybe.
So
Regular
that's why
visitor
if I
is
come
not-
out, I will be scolded by my junior friend.
My lord,
This matter has been taken so much.
your lordship is taking the hearing matter at 3 p.m. At 3:30 p.m. I have seen in the list.
Huh.
I have followed the list regularly because this matter and another matter is scheduled to come before your lordship in writ court. That I have already made my argument. This is reserved for judgment. Whether judgment is appearing or not, I used to follow up your lordship regularly after it is published in the website. So, my lord, your lordship is taking up the hearing matter, returnable motions at 3:30 or 4. Any day your lordship fix it.
Friday 3:30.
We no, not Friday. Friday, Mr. Basu will take the charge of in bar association number 2.
You are not with me.
Supplementary
affidavit filed in court.
পরের সপ্তাহে 17 তারিখের দিকে 17 দিকে ওই দিকে কবে আছে 12 আছে
সতেরো তারিখ 17th of March. The interim order. Initial appear under the heading further hearing.
Let's supplementary not record. Supplementary not record.
17th of March.
Supplementary not record. Supplementary affidavit filed for subsequent events.
Supplementary affidavit filed in court today is taken on record. Petitioners will be at liberty. Petitioner, the
Highlighted.
18th.
Oppose is subject to my lords.
Then let it be 19th.
No, my lord. It's not same. He has not even challenged.
Or similar.
My lord, I am ready to do the matter. It's not. No, not same issue. Not same issue, my lord. No.
Mr. Banerjee, I will be coming at 2 p.m.
Yes, that is
So
coming.
both of you will get sufficient time to fight against each other.
I am saying if that matter is decided in absence of us, then point of the jurisdiction of the that authority under section 14 is same.
You can remain present, Mr. Basu, to protect the interest of your client.
As pro bono.
No, hote nahi hai.
I was saying that matter also appears
No, my lord, kindly seize the last order. In apropos last order, I proceeded before my lord the DRT to take up the matter.
2 p.m.
I can come back.
I'll come at 2 p.m. Yes, Mr. Banerjee, other matters?
This matter.
So that
Not this other matter. Where is Mr. Kaur?
I am told that they have given their statement that we should put
No, that is getting examined. Allow us to come back at 2. And 2 o'clock.
এটা আবার হবে নাকি?
Show it to Mr. Kaur.
Yes, Mr. Kaur has only given this. I'll just show it to Mr. Bachawat. I don't want to repeat. Senior counsels are there. It's very
See that this does not happen because it may happen to any lawyer at any point of time.
not have happened. I want to have a word with Mr. Bachawat. I will personally.
God has saved me. God has saved me.
Sorted out, we've agreed on a.
Blood,
We'll file an
You have talked
affidavit.
to Mr. Bandopadhyay?
Yes, I've got his approval. Lord, only thing is that it has to be formed in, it has to be, Lord, in an affidavit form.
We will do that.
So, by the end of the day, Lord, let them file the affidavit by 3:30 or whatever. And Lord, I want to hand over, Lord, a copy which has been agreed to be kept on the on the.
Where is that?
I'll just hand up.
No. এটা ফাইলটা দিন।
We'll just hand up, Lord, whatever.
But an affidavit will be filed, but this will only be to show what the affidavit will contain so that there's no later dispute. It's only for that purpose.
So I'm passing orders on this scan in view of this. Scan 1 of 2025 order. This application has been taken out. Kaur, who has filed this application?
But, the client has filed the application, bringing on record the
allegations based against his advocate.
Senior advocate.
Paragraph 2, it is clear. Paragraph 2, kindly see the application.
আছে কেউ বলছে কি বললাম? This application has been taken out by the opposite party in the civil revision application, alleging that certain derogatory statements have been made against the learned senior advocate engaged by him to argue in this civil revision application.
And the junior advocate, the junior counsel. And the
it has also been learned senior advocate as well as other advocates who have been certain other advocates who have been engaged by him to appear, argue na kore, to appear kore debe na, to appear on his behalf in the civil revision application. To stop. Though several prayers have been made in the said application, but when the application is taken up for hearing, the Mr. Kaur, shall I record the name of Mr. Bandopadhyay or I will record your name?
Your Lordship can record my name.
I think it's better to record your name. Mr. Bandopadhyay, I am recording Mr. Kaur's name. When this matter is for hearing, Mr. Pachawat Lanet, senior advocate appearing for the opposite party in the application, and Mr. Kaur, Lanet, senior advocate representing the applicant in the said application, submits that the parties have mutually agreed to resolve the disputes which have been canvassed in the said application, and an affidavit in that regard shall be filed by the opposite party herein, tendering. Sorry, no. Opposite party in the application, by the opposite party in the application kore din, by the opposite party in can bole din, can 1 of 2025. কি বলুন তো সেন্টেন্সটা বলুন, এ হয়ে গেল।
Sorry.
Praying for unconditional apology. Mr. Bachawat, that is praying for unconditional apology.
Apologizing for the conduct mentioned.
Unconditional apology or apology.
Whatever is
Unconditional apology. First up, Mr. Bachawat prays for leave to file such affidavit on or before 3:30 p.m.
Yes.
3:30 p.m. today. A copy of such affidavit shall be served upon the learned advocate on record representing the petitioner in Can 1 of 2025.
The draft of the apology be kept on.
2025 on or before 4 p.m. today. Once the said affidavit is filed, the same shall be taken on record. The assistant court officer is directed to place the said affidavit on record as soon as the same is filed. First up, a draft. Mr. Kaur, can you ask both of you, Mr. Kaur and Mr. Bachawat, can you ask both of your advocate on record to put a signature in this?
Yes, I will.
So that a draft of the apology letter by the
affidavit, draft of the contents of the affidavit.
Draft of the contents of the affidavit has been filed before this court, countersigned by the respective learned advocates for the parties in Can 1 of 2025.
But the word letter,
Such
letter on top of that can be stuck.
ask your any of your advocate.
They will do it.
Let the contents of the draft affidavit be also kept with the record.
Lord, may I just have it signed?
So, with the above observations, Can 1 of 2025 stands disposed of. Now the order. I'm only reading the operative part. For the reasons as aforesaid, this court holds that the learned trial judge was right in not allowing the remaining witnesses to depose as DWs. Thus, the issue is answered in the affirmative and against the petitioner. This court, therefore, is not inclined to interfere with the impugned order. Accordingly, CO 307 of 2025 stands dismissed without any order as to costs. The learned trial judge is requested to dispose of the matrimonial suit as expeditiously as possible without granting any unnecessary adjournments to either of the parties. No cost, certified cost.
Much obliged. As early as possible by retirement. Lord, if your lordship Lord is kind enough to indicate Lord some time, because
Mr. Kaur, it's at the argument stage.
It is
that is why I have only said expeditious. I think any date has been fixed because I have passed this.
No, I don't know, Lord, what is the next date.
Lord, may I prefer stay? May I prefer stay because I'm
yes, yes.
But please consider that because these are vital witnesses, not
the argument has already started. There is no question of staying. Lord, we will try for fixing a date. For
that is, Ashun, after this order is pronounced, after this judgment is pronounced, Mr. Bachawat, learned senior advocate, prays for stay of operation of this order. First up, Mr. Kaur, what is your submission on the prayer for stay?
Lord, I am opposing prayer for the stay, and I am saying that the argument have commenced. So there is no question.
Mr. Kaur, learned senior advocate, vehemently opposes the prayer for stay. He submits that the suit has been fixed for arguments, and
3 days of argument has already taken.
3 days of argument in the suit has already been advanced. The prayer for stay is considered and rejected.
1 week if your lordship considers, Lord, 1 week if your lordship considers, Lord, Because there is no date at the moment in any case.
So it will take some time to. You will get 1 week's time.
Yes.
I should
get 1 week's
that
time,
will
Mr.
fix.
Vacha.
But your lordship is more practical than us. Your lordship knows the difficulties of having these matters listed. Give me some time. They just
Lord, kindly
2
do
weeks.
not.
It's not
Kindly
a,
do not, because
but
Lord,
there is no
question,
date as of now.
no question of Lord
Because
giving
Mr. Bachchat, I have given you.
No stay, my lord. Otherwise, it will be shown that the stay has been granted. Never
My
continue
lord
the
has
stay.
given reasons for not allowing any further evidence. So there is no question of stay.
If you
Your
want, I
lordship
can.
fe- no, if your lordship feels it's a point of law which is to be tested, perhaps your lordship will consider stay.
If you go through the judgment, points of law, I'm not is in your favor, but on facts, I have passed this order against.
I see.
On law, if you go through the judgment, most of your arguments have been accepted, but on facts, I have said that it cannot. So, point of law, that is also one of the reasons. Otherwise, I could have. Point of law, most of your submissions I have accepted, but on facts, I have held against.
application much okay.
You will get this server copy in course of by today evening.
Much okay.
Obliged.
হ্যাঁ লেটার পার্টটা করে এইটাতে দিন ক্যানটাতেও দিয়ে দেবেন ক্যানটা আলাদা করে একটা অর্ডার ক্যানটা একটা সেপারেট অর্ডার হবে
ওটা ওটা অলরেডি রেকর্ড করা
ইয়েস ইয়েস মিস্টার কট
that the draft load has been countersigned and we are just
ড্রাফটটা কাউন্টার সাইন ওটা ওই এটার সঙ্গে ট্যাগ করে রেখে দেবেন কিন্তু ওইটার সঙ্গে না এটা ফাইলের সঙ্গে এটা ফাইল পাঠিয়ে দিন ইয়েস চলছিল তো হ্যাঁ হ্যাঁ এগুলো চা
20
এটা না 20 20 নয়
22
ও 20 ও বাবা
Yes, my lord, I'm on behalf of the petitioner.
yes
My lord, the suit was filed on 8/12/2010 in the
issues have been framed
yes, your lordship, and
when the issues have been framed
your lordship, the last order, kindly see page number 40, the last order on 25/7/2024. The amended plaint was filed on behalf of the petitioner as the defendant number 4
the
died.
amended plaint after that any amended issues have been framed
No, your lordship.
so
No progress has been observed in the amended plaint. Therefore, the petitioner asked for the expeditious disposal.
Ashun, this application under Article 227 of the Constitution
No, your lordship.
so how can a direction for expeditious hearing be passed কি বললাম
Lordship, postal track report was sent of the
what is the fate of that কি বললাম
22.
22 is my application.
appear for the opposite person.
This is a matter where right 21, the same order is under challenge, 30th of August 2024. The issue is whether a district magistrate after issuance of an order section under section 14 becomes functus officio. The impugned order is the same that your lordship was looking at in the last matter. Lord, Mr. Banerjee opposes, so I leave it to your lordship now. Your lordship will
I'll
keep
say
it on
why
any
am I
day.
why am I opposing, my lord?
No, that's okay. I don't want to get into it. Any day that your lordship fixes, your lordship will have to hear this twice over, once from me and Mr. Banerjee, and then again probably Mr. Basu and whoever is appearing.
So the same day I can.
That's exactly what I was praying for.
It is
It's
not.
the same order.
It is not because I say so. I'll show the order also, my lord. Is that, my lord, in this matter, in that matter, there was this is a stark difference. In that matter, there was a challenge to the section 14 order. In this matter, there is no.
But I.
No, in this matter, there is no challenge to the section 14.
All right, I will hear that.
But I don't know how much time my learned friend will take. I assure my lord, I will take only 8 minutes by the clock. 8 minutes by the clock. This matter is no longer res integra. This honorable court has decided the issue. Justice Bhattacharjee, Supreme Court has decided this issue. I don't know why this
What is the issue?
The issue is that, my lord, once an order is passed by the, my lord, district magistrate.
Section 14.
Yes. That order is to be passed within a time frame. Once the order is passed, my lord, he has got the right to execute the order. That extension, my lord, is not barred under the law. He does not become functus officio, and it is decided by this court as well as by the Supreme Court.
The Supreme
But
Court
he may
doesn't
say
decide
no.
that.
He may say no. I will show the judgment.
He wants to rely on C bright. I know the judgment.
C
That's not
bright,
the-
B bright. I'm not on that. I'll show my lord the
bright.
judgment that, my lord, this issue has been decided by this honorable court by Justice Shobhoshachi Bhattacharjee as well as by the Supreme Court. But, my lord, they want to dwell upon it to keep the matter pending. And this matter, this particular matter, my lord, Justice my lord, Basu Chaudhary passed an order that this, my lord, the main application before the DRT will not be stopped. What fell from my lord in the morning? There's an order. We went and filed a put up. The judge
That
says
should not be stopped. because
yes. The judge says we will
that
not.
is a completely different.
Correct. It's recorded in the last order, my lord, of Justice Basu Chaudhary. The DRT says I will not take up the matter. Against that, I filed a CO before my lord, which is also pending. He says till this issue is, my lord, resolved, I will not take up the matter. I filed a put up. So obviously he'll take advantage, my lord. If I was in his place, I would have been also very happy.
I don't know what he would have done. I have not
So,
taken
the
any
issue
advantage.
is that kindly
He wants
takes
to
it up
argue
any
for-
days, any day,
If
lordship.
he wants to argue for 8 minutes, let him argue for 8 minutes.
Yes,
We'll set a clock time accordingly.
I'll show it.
The interim order initially passed on 19th of November
With the order, I went there. He said he will not take up the matter. So let that also appear
Who
on
will
the
not take up the matter?
DRT, my lord 3.
Where is the other CO?
Before my lord, I filed
No,
it.
where is it?
My lord,
When have you filed?
before this court, my lord, I have got the number even. My lord, may I
If
just
you have filed, Mr. Banerjee, on the date you have mentioned for listing in the presentation form, that will appear
But
or
this
has
was filed
appeared.
before the competent, my lord, the other coordinate bench when he was, my lord, his lordship was taking up the matter.
Oops.
It has not even appeared once, even, my lord.
But is it appearing in the list?
No, my lord. That is the difficulty.
Motion, it has not appeared.
No. তাই তো আসেনি
When have you filed?
Date বলো নাম্বারটা বলো না লেখা আছে মানে gives me one moment I'll give yes it is my lord CO 237 of 2025 oh it appeared as item sorry it is my lord 652 of the February monthly list 652
Of the February monthly list?
Yes.
It's not appearing in this list. Have you checked up?
Well, item number 652 of the February so this is February
That is being
yes
continued.
so may that be my lord also my lord tagged with this matter correct
Not tagged with this matter, let that appear separately.
So that, my lord, I cannot seek any order because, my lord, obviously, my lord, the order is there. He is not complying with it.
All right, so let it appear, thereafter it will.
Very good.
Otherwise, because that's if it is not in the list, I cannot pass
No,
an
it is
order.
there in the list, 652 of the February monthly list.
February monthly list, thereafter some matters have gone.
Yes.
So this is the list from that court which is being continued.
Yes, my lord, this was
If
filed
it is
in
not
February.
here in today's list, then it's difficult to pass an order.
I don't want an order. I want it to be tagged so that, my lord, I cannot seek an order
So
for that.
I have to direct that let this order be tagged along with that.
No, I don't think
Let
that
it
my lord
appear thereafter.
oppose for tagging.
No, but I have to pass an order.
Opposing tagging.
So if the records are not here, I
Let
can.
it come up. I'll seek an order.
Yes.
Only because he is appearing, I'm opposing tagging also.
No, I'm happy for that.
What is the application for? Can 1 of 2025?
That is for the extension. I
That was
believe,
for
my lord.
April. That you are
Extension.
dispose it.
So
Yes.
can 1 টা হচ্ছে extension এর তো ওই করে দেবেন তা this application has been filed for extension of the interim order বলে তারপরে যা বলেছি this
My application.
I am opposing, my lord. Your lordship remembers it is that application, my lord, where, my lord, I am the unfortunate father as well as, my lord, the
But
Father-
anyways, my lord, those points of prejudice will come to later. I'll just move my application only on a point of law. My lord, this
prior
is
to
a
that, my lord, may I just
May- may- no,
indicate,
no,
my lord, your lordship's order is not in compliance.
what order?
Lordship's order is not in compliance. My lord, I will
What
tell
was
your
the order?
lordship why they are before your lordships today.
What was the order?
My lord, kindly sees the child was to be produced before the learned trial court on a particular date. Just a day prior to that, my lord, they moved the application. Mr. Banerjee was not appearing then. There were different sets of advocates. Mr. Anindo Haldar and Mr. Jubair Ahmed kindly considers the order dated 29th of January 2025. On 30th,
Yes, Mr. Banerjee,
Complied,
upon
complied.
taking instructions, this was done.
complied with.
He's saying
29
not
January.
complied.
child has
I have
not been
taken-
there. Child does not come down on 30th.
My lord,
They preferred another
don't
application.
scream unnecessarily. Kindly have a look
Well,
at the
may I
order.
just indicate.
No,
Kindly
not
have a look at
coming
the
down.
order.
Video
Paragraph five.
conferencing on
Correct.
29 done.
Done,
That
done.
was done, but on 30th, the trial court, my lord, he was supposed to be present. He
So
was
where
not
is-
present.
So my learned friend will
Subsequent
not
to
try to
this-
hijack.
My lord-
30th is the order passed by the learned court below. I have prayed for a stay of the proceeding. My lord, your lordship's order, there is no breach. He wants to get in by arguing that and then argue other points. Your lordship's order was virtually, it has to be done.
I directed
My lord, may I just
29.
indicate?
I directed 29 that meeting to be done.
Yes, 29, that has been done. We are filing an affidavit. This
Now what
video
happens?
call-
Are you disputing that?
No,
not
we
this-
can't.
Now what happens?
Now
Let
let us come to the merits. Let us come to the merits.
This affidavit, your lordship will take on record.
Just, my lord, kindly looks. Why
He's
is
not,
doing
Mr. Banerjee, he's not disputing that.
Why is doing this? My lord, lordship has to understand the intention, the underlying
The
intention.
lordship has to understand the law.
Tomorrow, the child is tomorrow. Now the child is going to be produced again. There is an
I'm
order.
going to ask for the stay of that today.
How?
Sir, my
Kindly
learned
looks
friend will not address us like
Kindly look.
how
So
and
at his instance, my lord, in another revisional application, he consented to.
But he will not let me argue my case.
All right.
Let him argue. I shall address, my lord.
Yes, yes.
Let him argue. You will be having your chance. Yes.
Well, I'll indicate. Well, naturally, marriage, child, son, no? Son, Mother passes away, custody is with the grandparents. Father files an application under the Guardians and Wards Act 1980. Some disputes, there's a 498A, all that happens. It comes to the High Court where we assail, they assail, different orders are passed. It comes to the High Court. Most importantly, in a proceeding in this High Court, a memorandum of understanding is entered into, a settlement is arrived at. That the child for then is going to be with me. The father will have custody rights. He'll come and visit. This is the time when I was in Calcutta. And if I move elsewhere, I am going to inform the father of where the child is now situated. Now, we move to Bombay, then we inform the father. Father comes to Bombay, meets the child. We move to Pune, the father is informed. The father, knowing that the child is in Bombay, takes out an application here before the Howrah Court, which is the learned court below, which is taking up these matters, for seeking custody of the child. This is an application under Section 9. When this application is moved, several orders are passed. Against one such order, we come up before this honorable court by way of a 227 application, assailing that this was made actually for production of the child, the direction was given. Now, there, Your Lordship's coordinate bench directs us to produce the child on a certain given date, which is tomorrow. Now, before that, we have already filed an application
produced before
the learned court below.
So that order is still subsisting.
That order is still subsisting. The first
Mr.
time,
Banerjee, if that order is
was first time it was complied with. The child comes.
tomorrow, you are saying the coordinate bench has passed an order directing production of the child tomorrow.
No, that's right. So what I'm saying is this CO, this CO, this revisional application is on a different. Before all these orders are passed, we had filed an application based on Section 9 for return of plaint in the nature of an Order 7, Rule 10. That Order 7, Rule 10 application has been rejected by the learned court below. That is the order. This is a separate chapter, which my learned friend is now seeking to confuse the court with, saying, I'm not complying with orders. This is from an interlocutory application. The main list, which Your Lordship is now examining, is whether an application under Section 9 for claiming custody of a child under the Guardians and Wards Act of 1980
is maintainable before the Howrah Court.
That's right. That return of plaint application in the nature of 710 has been rejected on the ground. That is under challenge here. So that one issue, I'll show one section, probably not as Mr. Banerjee, I'll not take 8 minutes. I should not take more than 10 minutes of Your Lordship's time. Please have a look at the impugned order once. Somehow, in this, the impugned order has come up as the first order.
Yes, I have the certified copy.
Yes, that's the 4th October 2024.
Yes.
Well, disregards the whole thing. Your Lordship will come to page 3.
Yes.
Because page 2 last is where he's heard the submissions, and then there is one judgment reported to page 3. The position is not disputed that Section 9 of the Guardians and Wards Act provides that the applications for appointment of a guardian of the person of the minor, he shall be to district judge having jurisdiction in the place where the minor ordinarily resides. So, which place is considered to be the ordinary place where the minor son of the petitioner resides for the purpose of jurisdiction of the petition for custody of the minor child? The fact stated by the petitioner husband that while residing with his wife and son in his house within the jurisdiction of so-and-so within district Howrah, his wife along with his son went to her parents' house, which is situated at Bangur Avenue, Kolkata, which is within the jurisdiction of Lake Town PS, situated in so-and-so for a short stay, where she got infected with COVID and she was hospitalized, and subsequently the wife of the petitioner expired in the hospital, which is not disputed by the opposite party. The opposite party in their application under 710 Rule 10 of the CPC and Section 9 of the Act stated that the son of the petitioner, who is a minor, is a present resident of so-and-so, Pune, I'm just disregarding the address, Pune, Maharashtra, and is having his schooling there by filing the Xerox copy of the Aadhaar card and school identity card of the minor. The opposite party further in the petition paragraph 4 has stated that only the district judge of Thane, Maharashtra has the territorial jurisdiction to try the present miscase filed by the petitioner. In course of the hearing, the learned advocate for the opposite party has filed the present Aadhaar card of the minor The petitioner, along with the objection filed by him against the petition filed by the opposite, has annexed the advocate's letter given to the petitioner on behalf of the opposite party, has informed the petitioner the minor has been shifted to so and so in Pune. Now the question is, which of the three places above is considered to be the ordinary place where the minor son of the petitioner resides? Your Lordship will kindly notice the tense. Resides for the purpose of jurisdiction of the petition of custody of the minor child. Lordship will give me 1 minute. Mardana Mosque. The petitioner child of the minor child is moved from one place to another after an interval of certain time so as to avoid the custody application at any particular place by the OP. It will not be out of place to mention here. And now that in normal circumstance, a minor child usually resides with the parents. Abnormal situation in marital life arises out of the matrimonial dispute resulting in separate living of the husband and wife. In such case, the minor child obviously resides with either of the parents. Under such background, the applications for guardian of under section 24 or custody of the child under 24 are filed. The statute confers jurisdiction keeping in mind the benefit of the minor, so he or she may not be troubled from one place to another, being a pawn in the battle of between the parents. The matter in issue in the proceeding is to find out the answer where the child ordinarily resides. It is true that a temporary residence of a minor for few days, please mark this, that camping here and there cannot be treated as a place of ordinary residence of a child. In the present case, the child of the petitioner was ordinarily residing with his father and mother at his paternal house within the jurisdiction of Howrah, and that the mother of the child, for the purpose of visit her parents, went to her paternal house for a short stay along with a minor son, where she was infected with COVID positive, admitted in the hospital, and where she expired. It is alleged by the petitioner that when he went to bring his child at his in-laws' house, the paternal relatives of the wife of the petitioner prevented him from meeting and communicating with his minor son, and also preventing him from taking him back with him. So the petitioner left with no option but to file an application praying for custody of his minor son. The opposite party not only that in the meantime shifted the minor son of the petitioner firstly to Thane and thereafter to Pune. I have gone to the judgment of the Honorable Court, relied upon the learned advocate for the opposite party. In so and so, in the judgment relied upon the learned advocate for the opposite party, the master of custody of the minor child was in between the father and the mother, who were living separately with each other due to marital differences between them. And in that case, the minor child of the parties were residing with the mother. The Honorable Court was pleased to hold that the convenience of the mother should be treated as prime consideration, and considering the convenience and inconvenience of the minor child, transferred the custody matter to a court where minor child was residing with his mother. In the present case, there is no such, please mark henceforth, kindly see what he considers. There was no such marital difference alleged between the petitioner and his wife during a lifetime, incorrect, and they altogether were living in the house of the petitioner within the jurisdiction of so and so. The dispute only arose after the death of the wife of the petitioner, which was due to COVID, when she went to her parents' house for a short stay with her minor son. And after the death of the petitioner, the paternal relative of the wife of the petitioner, the opposite party did not allow the son of the petitioner to return him back to the petitioner and thereafter moving him from one place to another. The ordinary place of residence of a child depends on the factor where the child resides for a considerable period of time and where the child receives his initial education upbringing. Camping here and there with the paternal relatives of the mother of the minor cannot be treated as a place of ordinary residence of the minor. And considering the above factor, this court is of the view that before, please mark this, before the death of the mother, the minor ordinarily place of residence was in the house of his father, where he together lived with his father and mother and has received his initial upbringing there. And that place is the ordinary place of residence of the minor son of the petitioner, which is situated within the jurisdiction, and he dismisses the application under 710. So he...
please show me the application under section 7.
Yes. There's at page 38.
38?
Yes.
No. Not under order 7, rule 10. Application for custody.
Section 9.
Section 7. Section 7 of the Guardianship Act.
Yes. You know, that, no, section 7, the parent application.
Yes.
So the parent application is not annexed.
No. What is page 17?
Page 17.
Yes.
Page 17 is my address.
No. 17 is the miss case. That is the application under section 7.
Yes, I'm sorry. Yes, it's there. Alright.
So that has been
Yes, application under section 7. Look, here your lordship
this
will-
is the miss case which you want returned to be
to
transferred.
where the child ordinarily resides. Now, I'll show the section, my lord, and the recent Supreme Court decisions on this. My lord, the
Did
learning,
you file any objection against this?
the
Section
parent one,
7.
my lord, there was an order by which it was closed. My Lord Justice Basu Chaudhary has set that aside and directed us to file an objection to this.
Where is that?
That order.
No.
After that,
Objection to section
no, after
7.
that, we haven't filed it because that order was passed last week, I'm told. But this application has been pending. Your lordship has seen this order is of 2024. I filed this revision application immediately after that.
Yes.
That ex-parte order been set aside. Now, the only issue is that where is this application at page 17 going to be filed? This has been filed on the basis, what your lordship is looking at page 17, on the basis of section 20 of the Civil Procedure Code. Because if your lordship looks at the residence, and if I may say so, the learned code below has also gone on the principle that the child used to reside with the father, and therefore this has to happen here. Now, what is the practical difficulty that I face? Well, if there is an interim custody, why does the law require? I looked up, my lord, why is it that the prescription of the law is that irrespective of who is battling against one another, because it is about the welfare of the child is of primary importance here. So you look at where the child is and not where the warring parties are. Why? Because the child is, by God's grace, going to receive some education. If you're going to file for interim custody, you will have to bring the child, which is what is happening here now. The child is studying in Pune. The parents have moved pursuant to, the present guardians, whoever is in custody, has moved pursuant to a memorandum of understanding. The father has said, okay, you keep custody. If you go elsewhere, you let me know. We've gone to Bombay. Now, my job has shifted. The child is studying in Pune. I have an Aadhaar of Pune. I'm talking about the child. The child school diary, school leaving certificate, that the child is receiving an education in Pune and ordinarily is residing in Pune is a matter of fact.
What are you doing?
As in the child?
No.
Or me?
Child is studying. You.
Well, I am
fighting.
I am in employment and I am in Pune.
You are in Pune.
I am in Pune.
So it's a transferable job.
He's 70. I am not, I am a 70-year-old person. The child is with me. I'm the grandparent.
That is why I'm asking you. What are you doing?
I am unemployed.
You are unemployed.
I'm unemployed.
So what is the purpose for your shifting to Pune, Pune? What was the purpose?
My son, so I am the grandfather. My son was in Bombay.
But the child is in custody of not your son.
No, he's
your
with
custody.
me. So when I move with my son, I move with my grandson also.
All right.
And
so what is your son doing?
My son is in an IT company. He's presently
That's a
employed.
transferable job.
Yes.
So if tomorrow your son comes to Calcutta, so where will you be staying?
Well, it appears that the requirement is that
no. I'm asking you where you will be staying.
Well, that I don't know. If my son,
because you said that when your
But my-
son is traveling, you are also traveling.
my instructions are that now that the child is already in Pune and is studying in Pune, I will stay back with the grandchild. Because now he's receiving formal and is in class 4 or 5 now, no?
7.
Is in class 7. So it will not be.
The question from your conduct, it shows that you are moving from one place to another.
I've moved once.
No, initially you were in.
Went to Bombay. So the memorandum of
No,
settlement.
initially you were in
I was
West
in
Bengal.
Calcutta. I was in Bengal.
So at one point of time you were in West Bengal, then to Thane, then to Pune.
No,
Maybe
so
we do not know where we will be next moving.
No, so today when
Let us assume that the court accepts your prayer for transferring this to Pune. tomorrow you shift to Calcutta.
Well, this is where I am on. This is where
So
I
this
think-
proceeding, Mr. Banerjee, will go on from being transferred from one place to
So,
another.
Malad, as of today, the proceeding is somewhere where the child is not ordinarily residing. In future, Malad, one thing for a
So the
fact.
welfare of the child has to be taken into
Yes,
consideration.
that's right.
So if the
that will
child
make
is
a test.
if the child is put to a residential school,
No, the child does not. I'll indicate.
the court will consider with regard to their welfare.
No, that's right. So child was only one thing. This particular application under section 7 has been filed in a court which as of today has no jurisdiction. Because I am in Bombay, this was known to them, they file it here, your lordship will, may I just,
Why I'm asking you, if the child is being shifted from one place to another, so the proceedings will also be
may I just
transferred from
may
one
I
place
just
to another.
answer this query? Your lordship will have a look at page 17. Please.
Only interject.
No, please. May I show page 17?
Sir, you will be getting your chance.
Just
Please
have a
take
look at-
note what he is arguing.
Please have a look at page 17. I'll answer your lordship's query.
1-7.
1-7. The cause title.
Yes.
This is 1, 2, and 3. 1, 2, 3 residing at Bangur Avenue. Then Preeti Dave, Prashant Dave, both Thane, Bombay.
Child is in whose custody?
Child is in my custody. 1, 2, 3.
What is the name?
1, Shantilal Sharma.
So so practically 1, 2, 3 are that is relevant. 1, 2, and 3 is relevant.
So exactly my point. When this application is now that the child ordinarily resides in Pune, this application cannot.
Give me some
file-
dates, Mr. Banerjee.
Yes, ma'am. I'll give you the dates.
When your daughter died,
The daughter died. I'll give you lordship an exact list of dates. Arekta copy ache?
or first let us proceed from when your daughter came from her matrimonial home.
I have a full list of dates.
Yes,
I'll just hand
give
it
me
over.
that.
Arekta copy ache? Just bear with me for 1 minute. একটাই কপি এনেছে সফট কপি আছে এটা সেম ডেট গুলো লেখা আছে সেম ডেটস তো look this is not the whole list of dates. What is this? Come with one. Look, kindly have a look at it. I'm sorry, my lord, I have only one copy, but it has all the.
They have to be given a copy, Mr.
I also don't have one. Oh, I have.
Yes. Yes.
So marriage, 16 February 2010.
We are not on marriage when she left. That is the thing. You can
The
start
child
from
is
there.
born on 6 November. 18th April, daughter visits the house.
18th April. So
18th
this is
April.
the day when she
Visits
went.
the house. 8th May 2021, daughter succumbs to death. 13th June, I filed an application under 498A. 17th June, he files a counter criminal proceeding.
Mr. Banerjee, 498A filed by whom?
Me.
Me means the father-in-law.
The father.
After the death.
Father of the death. Father of the
Yes,
deceased
after
daughter.
after the death. And
this was-
Mr. Banerjee, the your daughter died out of COVID.
But the allegation
So,
is.
do you have a
there
copy of your 498
was- I have
application
a
now?
copy of the MOU that was signed.
What is
between-
the allegation? What is the date of occurrence? And
But I have
when
a-
the complaint was lodged?
I have the memorandum of understanding. Kindly have a
So
look at
that is
the
a
next
different
page.
thing. I'm asking you, when this complaint was lodged, what is the date of lodging the complaint?
This complaint was lodged on 13th
The
of June.
incident when it occurred.
498A is not of murder. 498A.
What
there was-
year? While your daughter
serious-
was at her matrimonial home, I want to know the date of the incident and when this complaint was lodged.
My lord, this is the complaint.
Yes.
Based on
You can
this
give the dates.
My lord, I have a copy of the complaint.
Yes.
Based on which the FIR was lodged.
Yes.
If you lodge
Date of the complaint and when the FIR was lodged.
This was on 13th.
Not the date of the complaint. Sorry, the date of the incidents on the basis of which this complaint was lodged.
No, so the date of the incident. So complaint is of 13th of June 2021 that your lordship will find from the list of
Is
dates
it in
also.
the list of dates?
Yes, it's a
Yes.
list of dates.
What is the incident which has been alleged in the complaint, date of the incident?
There's no one date. So from
What was the last day? Let us, first day and the last day.
I'll just look it up now. Kindly have a look at it.
Because till the date only.
Kindly have a look at it. Lordship wants to investigate into what has happened instead of me trying to kindly have a look at it.
I cannot investigate on 498A.
understand.
I'm asking you what is the date of the incident for
Kindly
which you have lodged
kindly have a
a
look at the complaint. I understand, my lord, but this is not very way to read. Kindly have a read it.
No, no.
Kindly read it. Just that one request, kindly read it. What prompted the 498 after the death? Death could have been due to COVID. What prompted my daughter to leave and come is what is probably highlighted in that. Death from COVID is unfortunate, but my daughter left her matrimonial home and came to me with a son who was then all of 7 years. 7 years old. MOU টা কোথাও? এটা দেখো।
When the marriage took place?
Marriage took place in 2010.
And the complaint against Dowry Prohibition Act by this complaint?
Also torture.
Yes.
And 2 lakhs that was there.
Yes.
And kindly have a look at the MOU that was signed between the parties, because there were counter allegations come to High Court. Kindly have a look at the MOU is disclosed.
It has been annexed.
It has been annexed. কোথায়? কোথায় MOU টা কোথায়? Kindly have a look at
page 28.
Page 28.
Yes. Which portion you are trying to rely upon?
This is between me, the grandfather, and the grandmother, and the father. Married to so and so. Complaint or all that your lordship will disregard.
Yes.
Parties sat together, dispute. Now page 31.
31, yes.
All the cases shall be withdrawn. Internal page 16 or the 31, whichever.
Yes, yes.
Cases intend to withdraw. Necessary join High Court. Kindly have a look at 1A.
What is the age of the son now?
12.
Yes.
Now,
yes,
kindly have a look at
particular portion you want to place.
33, yes.
33, yes.
33, serial number EF. F.
Yes.
That the parties of the first part change their address.
First part is you.
First part is me. First part change their address or residence place in future, or took the child with them in another district, state, or country. Then the parties of the first part shall inform the party of the second part about the living accommodation address so and so, and shall allow the party of the second part to meet or visit the child in their new accommodation address. So the MOU contemplates that I can, and the father was always aware that his custody is with me. I can change from one place to another because the father was aware. Today when he files, so today I'm in Pune, I'll show 2 more documents.
Yes.
And when I move, there is no allegation that I have not informed them. I have informed them. So the father knows that I'm moving from one place
According
to
you, there is no violation of that MOU.
Also, that that I can change along with the child is also to the knowledge and agreeable to the father. That I can, with the child, I can change. If I change, the father will come and visit. Now, what am I trying to do here? It firstly gets very difficult for me, probably your lordship, everybody here who has a child, to immediately think that the father is being denied custody of the child. The grandparents are going after the father because of XYZ reason. And I'm trying to lock the child up. No, the child is 12 years old now. The child really post 9, and I've looked up some judgments, post 9, the child has a mind of its own, which can have some credibility. That mind of a child who's 12 has a credibility in court. Now, the child is, I'll show documents, is studying in Pune. Why do I want this proceeding to go there? Because for every time that a child has to come, every time that a child has to be brought to court, every time the child is to be looked at or be asked questions, the child doesn't travel. It could be me as a grandfather, it could be him. So the law does not actually contemplate the difficulty of any person who is a defendant or a plaintiff.
Nowadays, Mr. Banerjee, that may not be required with this facility. Traveling may not be.
That is my whole.
Traveling may not be required with this facility now.
No, why? Now you lordship will kindly have a look at section 9.
Excepting, I'm saying, for the father. Court's requirement may be using this system.
For the father, because if the father wants.
For the father is a different thing, but not for the every time the court wants, child has to be
virtually travel. But apart from the fact that this time physically he has been directed to be brought, that's one bit of it. But your lordship will now in this context have a look at section 9 of the Act. May I hand over a copy, my lord?
But the child traveled from one place to another.
Yes, my lord.
But it's a fact.
It's
traveled from West Bengal to Maharashtra, Thane to Pune. So at that point of time, there is no difficulty.
No, the child is studying now. And if your lordship looks at the list of
studying, so he's not going out for vacations also.
No, that is different. He must be going out.
So that can be done.
Yes,
for
that can be,
but not for the purpose of attending or coming to the court if the court requires, not for the welfare of the child.
No, not that. No, welfare of the child is one aspect.
So the court can direct.
No, where can I institute the proceeding?
That is a different thing.
That is the only issue. I am on 710.
What is the meaning of the expression ordinarily resides?
Yes. Now your lordship looks at section 9.1.
Yes. Guardians and what's that?
Act copy, sir. I can hand over mine. Oh, no, I can hand over mine.
Guardians and what's that? Onion note. Onion.
That's right.
Yes.
It ki dichcho. Kisha section 9 arbitration act. Section 9, kindly have a look at. Court having jurisdiction to entertain application.
Yes.
If the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. So no other district court has jurisdiction.
What is the meaning of the expression ordinarily resides?
Now,
this section says ordinarily resides.
Before I take your lordship to a judgment, there's one request I'll make. Kindly make a note of the tense of the legislation.
Yes. Ordinarily resides.
In present. But
continuous.
That's right. In present continuous, where he's basically where he's residing.
So present continuous means from when? Whether at the time of institution or from a subsequent time.
So,
court has to look accepting present continuous. So the example which I gave today, let us assume not in this case. Let us assume the child stays within the jurisdiction of Calcutta.
When
I'm giving, kindly hear the example, then you see. So according to section 9, a court at Calcutta will having the jurisdiction ordinarily resides. Now the child travels to Delhi. So do you mean to say this has changed? Ordinarily resides at any point of time So this will change from Calcutta to Delhi. Now the proceeding, accepting your argument, is transferred from Calcutta to Delhi. He moves to Mumbai. So it will again be transferred from Delhi. So this ordinarily resides will change its connotation from
Your Lordship is
one point of time to other.
Your Lordship is looking at transfer. If the child keeps moving, will the proceeding also keep
Ordinarily resides have to be given a meaning at what point of time it will start.
That's right. I am very grateful. Kindly look at section 9 once more in this sentence that your Lordship has just expressed.
Yes.
In that context, just look at section 9.
Yes.
If the application is made with respect to the guardianship of the person of the minor, the next 4 words. It shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. So when I make it, so child keeps moving from Delhi to Darjeeling, Darjeeling to Northrix.
So at the time of making.
That's right. So when I,
At the time of making.
child was in Bombay. Child was in, this is what I'm at. What this expression that fell from your Lordship is what I was trying to labor to. That when I make it, it shall be made where the child ordinarily resides. So where the child ordinarily resides when it's being made, 2020, the father from 2022 knew that the child has moved to Bombay. How does he know?
When you move to Bombay.
Yes. I moved to Bombay 2022 in the list of dates your Lordship will find. In fact, in the school leaving, Lord, I'm very grateful for your Lordship to have made it easier for me. Because when I was looking up the Supreme Court judgment, because this ordinarily reside, Mardana Mosque and all that tense is to be looked at in interpretation. So I was also trying to think that what will be the legislation actually.
Point of time it is to be seen.
That's right. That's the main thing. When it is being made, and that is the incidence of the legislation. It shall be made where the child ordinarily resides. It's more or less that. Then I don't need to show anything more. 2022, the child has shifted to Bombay. And your Lordship will find that in view of
I think there is some mistake in this date because the next date is of 2021.
Yes, no, that's I'll tell your Lordship why. Because of this letter. So when the father institutes this in
this is
when he
whose advocate?
institutes in 2023, this is me.
Yes.
Grandfather. Because under the MOU, I'm to tell him.
Yes.
And from 2022, my school leaving certificate diary will also show, no? Page 65 will show. Page 68, your Lordship will have a look at. 58, your Lordship will have a look at once.
Page 58.
58. If you give me papers like this, there is no point doing a matter. Where
So
will I
can
get a
you
date
give
from?
me the exact date when you move?
I'm showing your Lordship the transfer certificate from Kolkata to Bombay.
In the school?
In the school. There can't be a better document. That school in Calcutta is giving a transfer certificate to the child to move to Bombay.
Page?
That exact page 58.
58.
Supplementary
There's a better copy in the supplementary affidavit. This I apologize. At least on my copy, it's almost illegible. The date is
less legible.
Your Lordship will find the first sentence. This is to certify grandson was admitted into this school on 2020 and left on 16th March 2020 with a good character. He was studying in class 4, being April 21 to March 2022. All the sums due to school on his account have been remitted satisfactorily. His birth admission register 6 November, so and so, countersigned, and this is issued on 16/6/2022. Post this, but he has been in Bombay. So,
what is the a document for admission?
Yes, that is also Bombay. Now, Bombay to Bombay, देखो. Page 65, your Lordship kindly has a look at one.
65.
আইপি ডকুমেন্ট লেখা আছে চাইল্ডটা বম্বেতে ছিল, মানে চাইল্ডটা বম্বেতে 2023 থেকে ছিল। 65 is the school leaving certificate of the child.
No, this is a school leaving certificate.
Yeah.
I'm asking you, you took this transfer certificate from Mangalam Vidyaniketan.
Your lordship's query is what do I have to
After
show?
that, when you got this child admitted,
My lord, page 66 is the identity card of the child, which shows grade 7 of the school, signed by the principal.
the date, I want to know the date.
Date of
After
admission of the
this,
child.
after taking this transfer certificate, when, at what school?
Admit the child in the school in Bombay. That date I'll find out. That date we don't have right now, I'll find out. But the fact remains that when in 2023 this is made, so if I come back to that section 9, my lord, at the time the application is made, the child is in Bombay.
Yes, what is the document to show that at that point of time, the child was studying in Bombay?
My lord, that I was in Bombay, I've informed the
That may
father.
not be relevant, child. You may be residing in Bombay.
No, I'll just indicate. My lord, documents to show that the child was in Bombay.
Because the court has to know how the welfare of the child is being taken.
2023.
After taking out the child from one school, what you have done with the child for this period?
No, he
When you have, so show me the
so
document.
That date, that yes, that I'll be able to show that document. No, এত কি কাগজ আছে বলো, চাইল্ড ওখানে ছিল, এইসব কি, এই আরে সে তো আনাতে পারবে।
And when the session starts in Bombay,
I'm sorry, Milan.
Session starts in Bombay.
March or April in Bombay.
So in June, you took a transfer certificate.
Yes. But my instruction of the child was admitted in Bombay, and from Bombay he moved to Pune. Immediately after, if your lordship keeps it on Monday, I'll show that document.
So from June, you took a transfer certificate. So in the mid of a session, from one school to another.
Correct. I will not understand that your lordship's concern
Because
about the
welfare is the ultimate concern.
No, here I am on only the jurisdiction, but your lordship's query keeps it on Monday. I'll be able to show that document when I have put the child in Bombay, because it's a very important question that has come. Because I'll have to show that on that day I was there, child was with me, is admitted. But your lordship's query I'll satisfy on Monday.
And what are the documents to show? Yes, what are the documents? The child had his or her Aadhaar card since when?
Child has his Aadhaar card in Pune already here.
No,
at page
not
55.
Pune. What was the date when the initial Aadhaar card was issued?
But I doubt there'd be two Aadhaar cards. Your lordship will have a look at page 55 once.
55. When it was issued?
The date of issuance is not there, you know. The document is here.
Yes, date is very relevant, Mr. Banerjee.
No,
because you are trying to show the permanent residence of the child at some point of time.
Aadhaar will show that the permanent residence of the child.
From which date?
Ordinarily,
so Aadhaar corrections can be made. If you change your address, Mr. Banerjee, if you change your address,
may not be the best example to give, but I got my son's Aadhaar card when he was 3 years old. For my daughters also when he was 3. So immediately after taking a child to Bombay, I may not have had an Aadhaar card.
I'm not on that.
But I will be able to show to your lordship.
I want to see that whether at a prior point of time there was an Aadhaar card.
Or before
or any document.
Correct. That he was that I'll satisfy. To show
that he's having the passport also.
Child has the passport. That I don't know. That I don't.
I assist your lordship with this, my lord. I was only hearing. Can you look at his address in the passport?
Yes.
I would require a little more assistance to show few more things. His prayer is, what is his prayer, my lord?
So this address is still remaining this.
Passport remains the same. Aadhaar card can be corrected any moment of time.
Golabadi, Howrah. Yes.
So I will
passport supersede, my lord.
I will
Aadhaar card.
I will not be able to show that when this application was filed, as apropos your lordship's query, that the child was in Bombay. I'll be able to show that because
I am on ordinarily resides, Mr. Banerjee.
But I am on it shall be.
Maybe he is residing anywhere.
No, Milord,
How? Because Mr. Banerjee, the ordinarily resides has to be interpreted and that has to be applied to the facts of a case.
that's right.
That is the only thing.
Judgment also.
Yes, that is the
There's
only
no
thing
point-
which is to be done.
Milord, the other aspect that I beseech your lordship to consider, of course, I'll satisfy your lordship's query because that's going to be an important issue. The only other aspect I'll beseech your lordship to consider is that the meaning of the phrase that it shall be made to the district court. So at the time, what had fallen from this honorable court, at the time that I make the application, at that time, where was the child ordinarily residing? Because that entire thing-
Ordinarily, what
that has also been
that is
interpreted.
the expression which is to be seen.
Milord, this
Expression ordinarily not only resides.
So that is what, so that it would be camping, where he ordinarily resides. And it's an interesting issue because if I take child goes from here and goes to Darjeeling for a holiday, that's not his ordinary place of residence. So what is his ordinary place of residence? Where the child resides, it can actually be given an ordinary meaning, which is why the language used is ordinary in the usual course, as how I would read it. The word ordinary, if I have to understand it, it would naturally mean in the usual course. In the usual course where the child was residing, that district judge will have to receive that application. So I will be able to show to your lordship, passport, Milord, is only going to show that he is an Indian citizen. And he may have a house here. His address may be here, but the child ordinarily resides. The legislation imposes
Mr. Banerjee, the
then
formalities,
I'm going to
you
make
must
it.
be much more aware than me.
No,
The formalities for obtaining a passport. So,
of course, I
here
will
it
be not
is
aware
being said as permanent address.
Milord, the passport
May be having different addresses.
But then, Milord, maybe. But the passport issuance, I haven't seen the document, but the passport must
Give a
have been
copy.
issued. Passport must have
If
been
you are relying
issued when
upon
the
anything,
mother was
give
alive.
him a copy.
Only one thing, Milord, I wanted to, Milord, since Mr. Banerjee is not concluding today, but I just want 2 days time to bring on record certain documents. Milord, since your lordship is deciding on evidence to some extent, what is there, what is not there, and I'll show 2-3 documents which will perhaps.
Let me see. Yes, Mr. Banerjee.
This date of issue is 2017. This passport. So the child ordinarily doesn't reside here anymore. That anyways is from. So this passport has the address of his when his mother was alive.
I will
That
direct him
can't be-
to give you this
Yes.
copy. He will be entitled to make submissions on
Yes,
that.
yes. Let him do that. Then let us do similar. To be fair to him also, if I want to rely on something, I'll give him those set of documents also. And then we can come back and address your lordship on all of that.
Milord, that would perhaps be better.
কতদিনের মধ্যে করতে পারবো বলো? হ্যাঁ? দাদা, বম্বে টম্বে থাকতো, ওগুলো তো করতো।
But Mr. Banerjee, tomorrow if there is a direction of the coordinate bank,
That has to be followed,
you
Milord.
have to follow that.
And that was a
For the
condition.
child to come physically.
That I do not know. Whatever the order is there, I am not interfering with that.
I think the child is anyways on his way. Child will.
As a
Child-
father, Milord,
So
I'm
don't
only
take the
concerned-
plea that this matter is being heard adjourned.
Will go.
He will not be
No, no, Milord,
produced.
the coordinate bench has directed. How will I come and say that I will not comply? That the child will go and meet. That direction will continue. The only thing is whether the list is going to be here or there.
That, Milord,
It has to be made where the child ordinarily resides. That is your lordship is that arduous task of deciding that your lordship.
So you
will
want
we
to
are in no rush, my
This
lord.
is with regard to the documents. So now you will be submitting with regard to these judgments. You can complete that. You can make those only the documents.
No, but it might be simpler for both of us to assist your lordship by relying on that, by applying it to some facts. So
May not
allow
be,
us,
if the facts may not be also relevant upon going through the decisions. Court may also decide.
that I'm ready. Your lordship has another 15 minutes, I'll place that judgment.
Because after all, he says that he will be taking some time. He cannot conclude
But your
today.
lordship will allow me to cite 2 more decisions on the next day. I'll cite this. There is a detailed discussion on what is ordinarily reside.
Yes, that is the only thing which is to be taken into
No,
consideration.
I want to take it a step before that. My lord, I will be trying to persuade your lordship that minor ordinarily resides this also has to be read, but the incidence of the legislation is it shall be made.
Yes,
So
yes.
when it is made, it is. So that date, as it has rightly fallen from your lordship, that date is of utmost importance. Ordinarily resides, I'll show. Ordinary resides, what is normally falling from your lordship is what, as all of us also understand as the word ordinary to mean. It would mean in the usual course. But on the day that is made where the child resides, so 2017 passport or a 2012.
I give you an example. I give you an example. Let us assume today the child is at Howrah. Now you kidnap the child today. Take him to Delhi. So where the application will be filed?
No, it's an extraordinary situation.
No, this is you have
That is
to
not-
you have to interpret taking those extreme cases.
No, my lord, I will beseech your
So,
lordship to interpret the word
Let us assume.
ordinary
Let us assume
as an ordinary
the
circumstance.
child was staying in place A. Now, to attend certain ceremonies in the relative's house, the child goes to place B. Now, from there, the child is not being allowed to come back. So, which court will have the?
But then he's not a resident there, is he? He's not a resident. But where the child is residing, today I go to a market and I go and like
What will be the child's residence?
Let us look at how your lordships look at summons. So I have a certain summons, let us say for a company or an individual, summons is to be issued. Where do your lordships insist, or what does the Civil Procedure Code require me to issue summons? Where? Where ordinary place of business, where ordinarily resides. If I leave that and I go and stay in a hotel, I'm staying there, summons comes there, I come and say, I don't know, summons was given, your lordships have never countenanced that. So even in the course of Civil Procedure Code for service, ordinary place of business.
You have answered the question which
So now if your lordship applies that principle to when it is being filed, so if that is the date.
So ordinarily where he resides.
Yes, so that is not Calcutta because I'm in Bombay. Well, can't be stretched to no form of imagination.
Forcibly, that is why I use
No,
the
no,
expression forcibly let us assume.
which
Forcibly taken to another place.
which is why I'm also saying that forcibly situation is an extraordinary situation. If we look at the case in hand, which is why I showed the MOU understands and the father understands that the custody is with me. I am and I can take the child elsewhere. All this in the ordinary usual course of things. If I take him, I'm going to intimate. In 2021, I intimate. In 2022,
There is no dispute with regard to that. He is not alleging that
that's
shifted without giving him.
That's right. So the moment he doesn't do that and he knows that the child is quote unquote residing with me, and that's in the ordinary course because he's not said I've kidnapped the child, he's filed an application for seeking guardianship. So he knows that when he's making the application, the child is ordinarily residing in Bombay. That is what I'm trying to argue. That when he's making the application, he's
Was in
aware.
Bombay.
I'm saying Bombay.
Bombay,
Correct.
so
So
Bombay,
Bombay.
which place?
The Thane, Maharashtra, that district judge. Thane, na?
So according to you, it is to be transferred to Thane, not Pune.
Thane.
Not Pune.
So it's
Not Pune.
no. Now the child.
If that is no. If you say at that point of time that was Thane, but not Pune. If this argument is to be accepted,
No,
so
they-
on the day when it was filed, the child was in Thane.
Lord,
So it
may
is
I-
to be transferred to Thane, but not Pune.
It may not be that difficult. I'll tell you, Lordship. Today, I'm assuming that the father would continue to pursue his right. So he shall make it today. So when he makes it
No,
today,
no. It's returned. It's not a fresh file.
correct. So return to court. It will come back to 9
So it will
prescription.
be through the process, it will be returned and he will be filing.
And
So it's
where-
not a fresh filing.
Not Order 7, Rule 10 is getting returned.
Yes.
Is getting returned now where? So if I come back to where the minor is ordinarily residing now, which is why I'm saying Pune. But I am saying because now it's going to go where the minor is ordinarily residing. Well, I understand your lordship is not with me. But if I have to look at it.
See, I was trying to see what is the expression. If that is so, that is the only relevant date. So it is to be only seen on that relevant date where the child was there. On that relevant date, the child was in Thane.
But when the application is being made, so when he is making it, He doesn't make it in Thane. When I apply 710, there's a return of plaint. It can't now go to Thane when everybody knows he's not residing in Thane. It has to go where it is now being made where the child is ordinarily residing, which is why I'm saying Pune. Under no stretch of imagination can it be Howrah. So let us first be very clear on this, that it can't, if I can.
May not be Howrah, but the place where it is to be transferred, that is also to be decided.
So that's the second hurdle that I have. The first hurdle I'll have to cross, and I'll try and satisfy your lordship on this, that when I'm making it, he is not in Howrah. He knows I'm in Bombay. Now when I'm applying under 710 saying this is a wrong court. So now the list is being carried from one court.
Your application, Mr. Banerjee.
Under 710.
Yes. Your application is for, Mr. Banerjee, this section 9 does not contemplate Order 7 Rule 10. It says the jurisdiction at the time when section 9 application is made. So that is the relevant date, not your filing of the application under Order 7.
No, correct. Not at all. No.
So when you are filing, you are in Pune, that may not be the relevant.
Well, a party, so let us look at it this way. A civil suit.
Accepting your argument.
Yes.
So it may not be.
Yes. So let us look at another example. A party has filed a civil suit. I take out an application saying, say the suit has been filed in 2014. In 2018, the Commercial Courts Act notification comes. I say that you filed it in the wrong court. There will be a return of plaint, not dismissal. It will get transferred. It will get transferred to a court which has jurisdiction now. Your lordship will not say that this had to be transferred when the 2013 court which had jurisdiction. It is
that is by Mr. Banerjee, there is a distinction that is by operation of law.
Same thing.
Not by operation of law.
May I
on facts.
Correct,
you are
correct.
transferring, it's not by operation of law, it's by operation of a statute.
Understand. Correct. That by notification that happens by section 13.
Likewise, the writ petitions in land matters, which has been transferred to the land. Yes. So those are pursuant to some law.
Very well. If I can at least initially show that it could not have been in Howrah, if I can satisfy your lordship on that it shall be made to the district court having jurisdiction. So this district court could not have had jurisdiction because when it was made, the child was ordinarily residing elsewhere. If I can satisfy your lordship on that aspect, then we'll have to look at Order 7 Rule 10. So what am I saying? That a court that doesn't have jurisdiction will send it to the court that has jurisdiction. When I'm asking for 710 and not 711, 710, I am telling the court that, look, you don't have jurisdiction, put it in a box and send it somewhere to a court that has jurisdiction today. So I take it to which court now? Now your lordship will look at this phrase as what? If let's say territorial jurisdiction also 710.
You kindly come to Order 7 Rule 10.
Yes. This is going to be one territory of your lordships which I will have absolutely no clue of. Thank you.
We have seen, subject to the provisions of Rule 10A, the plaint shall, at any stage of the suit, be returned to be presented to the court in which the suit should have been instituted.
Correct.
So suit was instituted in 2023 when you were in Thane. So transfer to the court where it should have been instituted according to you is Thane, not Pune.
Now your lordship will have a look at 9.3.
Yes. Yes.
let us say if it is now made in Thane, and your lordship knows, I know, and the father knows the child is residing in Pune, kindly have a look at 9.3.
Yes.
If an application with respect to the guardianship of the property of a minor is made to a district court, other than that having jurisdiction in the place where the minor ordinarily resides, the court may return the application if in its opinion, the application would be disposed of more justly or conveniently by any other district court having jurisdiction.
Having jurisdiction.
Having jurisdiction. So here, well, therefore,
here you say
if I-
it does not have.
Let us say I have two parts to this. First is I'll have to show that this court doesn't have jurisdiction. Second is if this court doesn't have jurisdiction, where is it going to go? Will it go to Thane or will it go to Pune? On this I'll come back.
Just before parting ways, adopting to Mr. Banerjee's submission, my lord, since he has said, my lord, the court should be in Pune, my lord, kindly have a look at his application.
Where I
He
said, Thane.
Yes, Thane. So it cannot be in contradiction. I cannot be made run to Thane, Pune local, my lord. It cannot be like that.
He is not so unfortunate. He doesn't have to run between Thane, Pune.
Where is it? Where is the
Kindly have a look
application?
at page 39 of the revisional application. His prayer, my lord, he must amend it at first or file afresh. Otherwise, his order 7 rule 10 goes. He's arguing on Pune and he says Thane. It's his prayer, not my prayer. He's relying upon this.
Which page?
No, page 39. Kindly takes, my lord, paragraph 4. It's his pleading. District Judge of Thane, Maharashtra has the territorial jurisdiction. He asserts that right. Only district judge at Maharashtra. Now he says the child is in Pune.
Mr. Banerjee, your case is at Thane.
It makes my job easier than Thane. Then I don't have to trouble your lordship with this at all. Then I'll just have to show that on that day, he could not have been in Howrah. I'm very grateful to my learned friend.
So, my lord.
This other thing, no, this is very good. Then we'll go to Thane. If I can show that on the day when it was made.
You are accepting this.
Thane.
So, but according to your own submission, the child is not in ordinary residing in Thane, but in Pune. Cuts both ways.
No, it's not.
If this is accepted, now it is in Pune, not in Thane.
I'll indicate them. Why we've said Thane and why not Pune? I'll indicate.
That is the application.
Correct.
Not
correct.
why.
I have not filed a modification or anything. I'll come and explain that. Why Thane and why not Pune? Or why was Thane made then? And why not Howrah? At least not Howrah. It can't be Howrah. Under no stretch of imagination can the father apply section 20 of Civil Procedure Code and say, part cause of action is arisen here, therefore I filed it. That can't be his basis. Now, I understand that.
Where is the jurisdiction part said in this application?
No, there was no other basis for him to do it. He's done it fraudulently because he knew I was in Bombay. He wants to use this to bring the child and the grandparents who are 70 years old.
Yes, Mr. Banerjee, what the example which I was giving, his case is exactly that paragraph 14. Eloped with the son of the petitioner. That is his case. The example which I was given. Forcibly taken away from this place to another.
Filed, my lord.
That is practically his case. Without going through that,
but I'm
I was
showing
giving
that
the example.
To the MOU, he has letters, he knows.
That is a different thing.
But I will rely on the MOU, my lord. Perhaps then I will be entitled to a degree.
There is no FIR, nothing.
No, this is
that is before the court. Your lordship, the revisional court. The rights have no. He knows I'm in Bombay.
My lord, kindly have a look at the MOU, page 32.
All the more reason your lordship has seen that
I'm entitled to a decree in terms of the MOU.
One second. He writes that I'm in Bombay.
If the child is willing to
Yes.
give to you.
Now, how the child is willing or not, that the child has to only ascertain. Child has not been brought.
Child
Child
will
has not been examined by the court.
The penalty. Child will be produced.
Child is
Come back after.
So let us. It will be better if the
mind of the child is also known. Yes. Well, that is anyway
not before this court. Let it before be done before the district court where it is being.
That specific instructions were given not to interfere with that order. The child is on his way. He's going to come and get. He's going to there and probably going to meet the learned judge there. That is the direction.
And Mr. Banerjee, this is one thing. After all, he is the father. Now, During the lifetime, there was
But
no
I
allegation.
understand that that is the only thing that
During
was within
the
conscience
one
of the
thing,
court.
one thing, during the lifetime of the wife, there was no allegation of this 498A. So wife did not file any complaint. Death is not on account of that torture. Death is on account of some
Yes,
illness.
natural cause. It's a natural
Some
cause.
illness. So now, after all, he is the father. So does he not have a right to get
100%.
custody?
Well, the father has himself signed the MOU.
Mr. Banerjee,
Well,
maybe for what
it's-
reason that MOU was signed
But
at
beyond-
that point of time,
I
nobody
can't-
knows.
I can't.
But
feel-
after all, can you deny the right
No,
of the
I'm not.
father?
No, I'm not. But beyond the point, I also can't peel off every aspect of the father's conduct just purely on conscience. The father has himself signed the MOU. The father has himself allowed the child to go from Calcutta to Bombay. All this is a part of the father's conduct too. Simplicity on my understanding of my conscience. I can't peel off every aspect of the father's conduct. I understand that the conscience of the court is getting pricked like every other father here. That why won't the father have it? But would your lordship allow your sign an MOU that a son will be with my grandparents and this is going to go?
Mr. Banerjee,
There
Mr.
is
Banerjee,
pleading that the
Banerjee,
MOU
that
was
was
signed
in
under
connection
duress.
with a criminal proceeding.
I understand that, that your lordship will
That was,
raise that.
MOU was entered into in
both
connection with a proceeding
No, it
when
is
a criminal proceeding was pending.
nobody's case anywhere that the MOU.
Nobody knows.
No, I know.
What was the
because-
compelling reasons for signing of this
My lord, it
MOU?
is
MOU does
nobody's
not take away
case.
the right of a father.
My lord,
It's the
MOU
statute
is
guarantees, my
nobody's
lord. That's
case.
my only
It was
point.
under duress. It's been 3 years. since
Either way,
filing
the
of
MOU
the-
might interpret it.
It's been 3 years since filing of the MOU.
What is your
Nobody's
age
case-
now?
Mine
What is
70. 70. 70 years old. It is nobody's case that the MOU was signed under duress. It is nobody's case here that the child had been taken away.
Let us come back, my lord. Let us come back with the documents, my lord. I will rely on certain documents. Let him also.
We can just exchange
all
all
that.
that.
Will decide this.
Lordship
This is the
keep
point.
it,
Your lordship will decide after hearing both of us. He will rely on something. I'll also rely on something. There cannot be any judgments without facts.
So we'll come back, my lord, any day next week, your lordship.
আরেকটু সময় নিয়ে নাও, তারাও-
Not next week, let it appear. Yes. Heard Mr. Banerjee, learned advocate, appearing.
Of the order passed by my lord Justice Vasu Chaudhary is all right. Consider the stay of the proceeding henceforth.
What's
Because
the of the proceeding?
of the matter going on before the learned court below. This is an arguable issue that is there. Stop saying why. This is an arguable issue that I've raised. This, if it continues, then the evidence is going to start, and I have to keep coming here. Then the entire thing is, I can come on Wednesday, because next date won't be Wednesday. But if your lordship is keeping any day after the next week, then considering staying all further proceeding.
Mr. Banerjee, you cannot have any difficulty in coming. The child need not come every day.
Not that.
Child
Not
need not come every day.
the proceedings, at least.
What is the
time
next
of-
date fixed?
Tomorrow.
Tomorrow you are producing.
After that, I don't know. So the next date is going to come, and then it's going to start. The trial will
May I
start.
just
evidence will
indicate
start.
one thing? I have not
No, but
interrupted you.
I have today, I have at least prima facie been able to show that this court may or may not have jurisdiction. Whether Thane, Pune is something else, but Howrah court really may not have jurisdiction. If there is an issue of jurisdiction and this proceeding continues, there is going to be an issue. Then every step I have to come and challenge every order. and
Banerjee,
say
you
it
are
is not.
To me, you are trying to cross the first hurdle, but till now you have not crossed.
So that's all right. No,
So,
I understand that that is okay. No,
so prima facie, till now, nothing.
Prima facie, at least your lordship has heard me. The issue of jurisdiction is at large. So when the issue of jurisdiction is at large, at least with immediate, with undue haste, it should not proceed. Stays it for a bit. Let us.
So what is the frequency of this Howrah court? Howrah
Every
court.
week a date is being
What
given.
is the,
I am told every week a date is being given.
every week?
Yes.
Because of their conduct, child was not being produced. Child was not being produced.
No.
Court's orders being obliviated day in and day out.
So that is being complied with.
Now they are
day.
trying to
So
comply.
when we come, the judge says, I'll show that order. Justice Vasu Chaudhary.
No, I have the entire order sheet.
All right,
Say,
how much
by
time you will be able to file your supplementary?
Within a week's time.
I
As
can also do that. Well, kindly
It's not
consider the stay
affidavits,
of proceedings.
affidavits of exchange, my lord.
Correct, correct. I just share the document.
Mr. Banerjee, learned
The
advocate, appearing
supplementary
for the
affidavit in the
petitioner,
sense, my lord.
commences his argument.
Chatterjee, wow, wow.
No, no, I want to artist.
Grateful, man. Your lordship is very kind. Grateful. Grateful.
PPM matter to Dakur?
My lord, may I take back the Guardians and Wards Act?
Yes, yes. Guardians and Wards Act. Yes.
I'm extremely grateful.
639.
You have not taken any resolution, Mr. Chatterjee. You are not bound by the resolution. You are not member of the Bar Association.
No, I was only, my lord, wondering, my lord, that if the report can be circulated and we come back on Monday.
After 3:30. So, can be done. So, let the matter be taken up. Yes. Right.
স্যার আমার মনে হচ্ছে আমরা ট্র্যাপে পড়ে যাচ্ছি না না হয় না
Yes, yes.
আমরা ট্র্যাপে পড়ছি স্যার এটা করা যাবে না এটা প্রেসিডেন্ট ওপরে দেখিয়ে অন্য জায়গায় গন্ডগোল করে দেবে খুব গন্ডগোলের জজ স্যার report can I take, then I can. We have come to court, we have done so much work.
Lord, for the petition, Mr. Banerjee, yes,
For
Mr.
the
Banerjee,
petition.
start. Start.
Now, my lord, a very short question. Lord, short question is,
The report.
Lord, short question is,
Let me see whether the report is. Yes, yes.
Lord, a very short question, my lord. Point is, my lord, that the suit was filed, then it was brought in under clause 13 of the letters patent. Lord, plaintiff filed a suit, plaintiff being the owner of the property, landlord filed a suit.
You are the plaintiff.
I'm the plaintiff,
Petitioner also.
petitioner also. Now, my lord, eviction and other reliefs also, other suits also analogously had. Now, my lord, with regard to eviction degree,
What is the nature of the property?
dependent, that is
What is the nature of
nature
the
of the immovable property along with factory set is there. Now, my lord, in that case, the defendant, my case is, he's a governed under the defendant is governed under the West Bengal Premises Tenancy Act. He's a default and subletting. These are the two grounds for eviction, hardly contested by the judgment data.
evidence was taken in the original side. Then, my lord, after the evidence was taken, trial was held, and then it was found that, and his further defense was that he is a
Trial
weaker
was,
tenant.
in the original side.
Original side, because it came under clause 13 of the latest patent from the
Yes.
trial judge. That is why it came to the original side.
Then how revision?
That is why I'm telling your lordship. A very short.
Thereafter transfer.
Then very short point. Then, my lord, the case of the defendant was he's a Thika tenant, not premises tenant, under the Premises Tenancy Act. Second, that since he is a Thika tenant, therefore he is not evictable. Court held he is not a Thika tenant. But at that time, the decree was passed sometime 1980 to 83. At that time, 2001 Act did not come into force. Then decree was passed holding that he is a tenant, he was a tenant governed under the West Bengal Premises Tenancy Act. And he is a defaulter, and also he is guilty of subletting. That decree became final. Then that decree was put into execution in this court. This court transferred the execution case because the property is situated within Howrah. Therefore, execution case before that court. Now, my lord, execution case, my lord, he filed an application. Mr. Chatterjee's client filed application, 2 applications, because the different company, claiming that he is a Thika tenant and sublessee of the defendant.
What is the caption of the application? Section 47.
Order 21, Rule 97, 101. But his case is that he is a Thika tenant. His case is he is a subtenant Thika tenant.
He is the judgment debtor.
Judgment,
not a third party.
He is a third party.
So you did not obtain decree against Mr. Chatterjee.
I did not obtain decree against Chatterjee. But I obtained a decree
party.
against a judgment debtor.
I was thinking that he was
on the ground, yes, on the ground that judgment debtor, on the ground that judgment debtor is held guilty of subletting.
In favor of Mr. Chatterjee.
In favor of Mr. Chatterjee. In favor of Mr. Chatterjee. Now, my lord, what he is required to say that either he is a protected subtenant under section 16 of the West Bengal Premises Tenancy Act, and with regard to the claim of his Thika tenancy, Lord, if original landlord is not a Thika tenant, then his tenant cannot be a Thika, claim cannot be a Thika tenancy. Because Thika tenancy determination has been made by the High Court by holding that his landlord was not a Thika tenant in respect of the property.
So what happened to that order?
Yes, my lord, then 97 application, relying upon, my lord, the judgment of 3 judges bench, we said that this is their case. On the basis of their case, no evidence is required. And therefore, it can be on the basis of his allegation mentioned in the application liable to be rejected. The trial court held you are claiming to be a Thika, you are claiming to be a subtenant under the judgment debtor. He is coming through a judgment debtor. Therefore, he is bound by the decree under Order 21, Rule 35. And therefore, the only inquiry is to be made under Order 21, Rule 97, whether he is bound by the decree or not. Register is allowed to, can entitled to register the decree or not. This is the only question. Lord, over this question, my lord, there was that the appeal was preferred. The petition was rejected, then appeal was preferred. Now, appeal court admitted the appeal. Appeal court admitted the appeal. Lord, because, my lord, it is judgment of this court, my lord, previously miscellaneous appeal, now, my lord, it is a title appeal, as if it is a title appeal.
What is the title appeal? Order 21, Rule 97.
Rule 97, miscellaneous appeal. Miscellaneous appeal.
Not a title appeal.
But, my lord, there is a judgment of this honorable court by saying that no, it should be a title appeal. Whatever may be, we are not
title appeal.
I am not concerning with regard to that. Degree, because it is a deemed degree.
103.
Yes, it is a deemed degree.
80 volume 1 CLJ?
80 volume 1 CLJ, my lord, was.
Yes, it says miscellaneous
Yes,
appeal.
80 volume CLJ, my lord. No.
That has been
80 volume 2 CLJ.
80 volume 2 CLJ. That has been overruled.
No.
So,
This judgment that my learned senior friend talks about, Lord, is a judgment which did not even take into consideration 82.
No, no.
never took into consideration it.
So now, against the title appeal,
No, it's not miscellaneous. Even here,
miscellaneous appeal.
This would be miscellaneous appeal, whatever, because 80 volume 2 CLJ, my lord, that is judgment of Honorable Justice Chittoswamy Mukherjee, with reference to with reference to appellate side
was the reasons why miscellaneous
that was the
appeal,
reason,
not a regular appeal.
why miscellaneous appeal, why not regular appeal? Now,
Also, that
whatever
there
is
is
my
no caption for this deemed degree.
right.
Either appeal against degree.
Lot of problems. Now what happens is that under the RERA Act, there is a provision for a second appeal. Under the RERA.
How it will be classified?
How will it be classified?
Cannot be a decree, so it cannot be a.
Said it will operate as a degree.
So deemed degree.
Operate as a degree, not even deemed as a degree. So now people are filing SMATs, but I have my doubts on that.
No, but in that case, my lord, the appellate side rules are required to be not.
Absolutely.
Appellate rules are required to be amended. But unless the appellate rules are amended, my lord, then second appeal. Degree second appeal. Unless appellate rules are amended.
Every order, my lord, is deemed to be a degree and it has to be a second appeal.
Every order.
Every order.
Every order.
Any order.
Yes, under there.
Other side, ma'am.
Yes.
Any order.
Yes. Mr. Chatterjee is right.
I think any order was in DRT. In DRT.
But that was overruled later. Overruled later.
That it was held that any order has to be a final order. Has to be read as a final order.
Has to be read as a final order, right.
So went and he had a certain other judgment that Mr. Rajgupta went and submitted, then he said it has to be a final.
Yes.
Now, my lord, the London district judge, my lord, the appeal, in appeal, Lord, in appeal, Lord, it has been stayed without any condition. Now, Lord, my respectful submission would be, my lord, that in all cases, stay is not under order 41 rule 5, certainly with condition, but not in all cases. If expressly it appears that appeal is maintainable, certainly, but there is no merits in the appeal, why there will be a stay?
But the appeal has to be decided then. May not be the stay, you may be right, that if the main matter can be decided, then the question of keeping the appeal pending, stay rejection.
Lord, on that day itself, it could have been disposed of.
That is a different thing.
We said that. But still then, my lord, they have, Lord,
what is the order here?
Why it is illegal? I am saying on twofold reasons. First is that I am a holder of
a challenge now.
Yes, that order we have to order.
Show me the impugned
yes.
Order says there will be no condition, but there will be no adjournment whatsoever.
Maybe, but even then, my lord, the steps are being taken. Case is not ready for hearing. Lord, your lordship kindly come to 2845. There are two revisional applications.
This is 2845, yes.
2845. Now your lordship.
What is the order under challenge?
Yes.
Order number 4.
Order number 4. Today is fixed for hearing of the stay petition filed by the appellant. Respondent number 1, caveator, filed written objection. Record is taken up for hearing. Learned advocate for the appellant submitted that the appellant is in possession of the suit property, setting up a factory therein.
Mr. Banerjee, directly, what is the stage of the miscellaneous appeal? Let the miscellaneous appeal be decided.
Lord, without any trespasser is allowed to occupy the property without any condition. Number 1. Number 2.
May I tell you, as you said, it's only a point of law.
This is first point. Second point,
that is only a point of law. So, what is the next date fixed? I will direct the miscellaneous appeal to be heard. If it is only a point of
second point. Second point, my lord, he is claiming in his application order 21 rule 97, 11 decimal, two cases. Lord, I am holder of a decree to more than 2 bighas. Why entire degree is the state? That is totally illegal non-application of mine. I'm entitled to degree so far that party is concerned. Because he is claiming in respect of only his property.
Show me
He is
his
claiming.
claim.
Yes.
Show me his claim. In
Yes.
Order 21 Rule 90.
Yes, kindly come to his petition.
Which page?
Lord, order 20 page 63. Order 21,
3.
rule 90. Yes, page 63, my lord.
Uh,
Lord, a state where your lordship kindly come to.
Show me the schedule.
Yes, that is why schedule. I am coming to the schedule, my lord. Page 69.
Page 69 is the objection.
Objection. 60.
68, yes. Where is the schedule? It says, what is the portion which Mr. Chatterjee's client is claiming?
Yes, that is, my lord, your lordship kindly come to paragraph 2, page 64. That while being seized and possessed of the aforesaid property, opposite party number 2 inducted one super trading opposite party number 2. My lord, 2 means the judgment debtor. The super
Who is representing the judgment debtor?
No, representative judgment debtor, we have served the copy, affidavit of service we have, but application in between him and myself.
In respect
That
of a
while
portion of the aforesaid property.
aforesaid property, opposite party number 2 inducted one.
So you obtained a degree in respect of 17 bighas, 7 katas.
Yes.
So that is the digital property.
He is claiming.
And Mr. Chatterjee's client is claiming
10
interest in respect of 10 katas and odd.
Yes.
So, but where is that specification? Which portion he is claiming?
He did not specify in his petition. Now, my respectful submission, judgment debtor or judgment debtor representative must know where the property they are occupying. Would your word say, Ramsos?
Yes, Mr. Chatterjee.
He shall be bound by the degree.
This 10 katas.
When the matter was taken up for hearing, Mr. Banerjee Millard did not object, or rather Millard wanted Mr. Mukherjee to be appointed to go and see where I am in possession.
I appreciate that. Show me your case where you are in possession.
Yes.
I cannot identify Millard in that manner. I can't say butted and bounded because in that 17 katas, Millard, I am in portion of one portion here, one here, one here, and one here.
No. According to them, not.
Together.
Not.
There are 2 plots, 12 and 10. So that 12 and 10, the Honorable Single Judge, Justice Basu, wanted it to be identified. And he would
Without first requiring you to specify in which, show me that. I want to know that specification, which portion you are occupying.
Your Lordship,
Otherwise, Mr. Chatterjee, is it not fishing out of evidence?
Look, what happens is that
Show me your case in which portion you are claiming title.
he has obtained a degree with respect to the entire property.
Yes. 17 bighas. So you claim
Number 27, Nityodhan Mukherjee Road.
17 bighas.
My lord. Now, in that 27 Nityodhan Road, it's a flat land. So I cannot really say, Millard, that I am in possession of this part. There is no demarcation there. That is why I could not, Millard, in the objection, give your lordship, Millard, a specific thing with respect to, Millard, my demarcation. I have the lease deeds with me from which I have plot number 10, which is relied upon by them. Kindly have
Plot number?
Plot number 10 and plot number
Lease
12.
deed.
No, their map, their document.
No, it's submitted before the court.
Give me a minute. I will give you time. What is your case? You are inducted by virtue of certain instrument.
Yes, Millard.
Where is that instrument?
Produce that. It's not there.
That was not produced.
It was not produced. Because the trial court did not give me an opportunity to produce.
Yes, certainly.
The court said that I will have to give you an opportunity to produce it. That is why I will hear out the appeal. This is what is there, Millard, in the impugned order. Have a look at the impugned order.
Yes.
And it turns to the impugned order once, Millard.
22nd February.
Yes.
Yes.
There, Millard, the lordship will find at page. Page below, the second page, just above that. Upon hearing the both sides at length and considering the materials on record,
Yes, upon hearing, yes.
materials on record, the learned trial court disposed of this case of disposing of the petition dated 27/9/2023. As such, in considered view of the court, the appellant should get an opportunity to be heard in the appeal. The learned advocate for the appellant submitted that the next date is ATO and then the stay was granted. And the impugned order, my lord, in the trial court was, my lord, if your lordship comes back.
But can there be, Mr. Chatterjee, an unconditional order of stay
Because the learned judge has said there is a condition. The
for adjournment?
No adjournment, will hear it out immediately.
But you are occupying a portion of the 10 kathas of the, against this order, there is a challenge.
Buying 10 kathas of the property. I have a right to that. That right has not been adjudicated. Today it's either basically at the time of filing of order 7 to 11. Basically, there is no evidence.
Or what? Your case, Mr. Chatterjee, your case, admitted case, you are occupying 10 kathas. So you pay that. It's not their case. You are occupying, it's your case. So you have to pay.
With change of determination. He had said that I will take away whatever I have, I can remain in possession, and the rest he is going to execute the others. That is why Mr. Mukherjee was appointed to find out where
No. My, he is wrong. Bloody, his lordship view was.
That's the order.
No, his lordship view was.
Interrupted you. That's the order. You have a look at Justice Basu's order. You can't play hot and cold at the same time.
Yes. 21st of August. Yes.
21st August order tha দেখো না কোথায় order গুলো গেল কোথায় দাও
We don't have a copy of it, but Mr. Mukherjee should have a copy.
Copy is not needed, Mr. Chatterjee, nowadays, soft copy. We'll be having there.
I like it.
Correct. 21st of August 2024.
Currently referring to a sketch map annexed at page submits the orange colored portion in the said map is under the occupation of Mr. Chatterjee's client, and the portion colored green is in the rest of the.
Which portion you are placing?
Page 2.
Page 2, yes.
Top.
Mr. Banner, yes, referring to a sketch map.
Annexed at page 100, which one I wanted to show your lordship. Submits that the orange colored portion in the said map is under the occupation of Mr. Chatterjee's clients, and the portion colored in green is the rest of the suit property. To work out the suggestion of Mr. Banerjee, the court appoints Mr. Conman Mukherjee, advocate as special officer.
Yes, where is that sketch map?
100, page 100.
Are you accepting this, Mr. Chatterjee?
That is what Mr. Mukherjee was saying.
So if you dispute this, Mr. Chatterjee, you must be having some sketch map.
I have.
Where is your sketch map?
There is no sketch map, my lord, in the application order.
Mr. Mukherjee was appointed. You have a sketch map. When you dispute this sketch map, you must be having.
Right now, my own document, I can come back. If your lordship wants me to, my lord, produce my defense here, I'll come back with my defense. I don't have a problem. But today, my lord, I don't have a defense. Appreciates my problem. My documents have not gone into evidence. My documents are not there before the court. He wanted to, my lord, take possession of whatever I am not in possession. 1 lakh is spent on Mr. Mukherjee, my lord, to find that out.
Who has spent that amount? Now suppose the report will be against any one of you.
I don't know.
Maybe against any one of you. Will be against any one of you. Then maybe I'm not saying against you or against Mr. I'm saying against any one of you. Then what will be the, can the court decide with regard?
No, my lord will relegate it back. This will be a piece of evidence which needs to be proved. He will go and give Shaki there.
Yes. Has to be. Has to be examined.
Not me. He will be cross-examined.
Has to be,
the
report is to be taken on record.
Lord, what I am
Banerjee,
doing, no, may I tell you, Lord?
It's troubling me.
Yes, I'm answering that. I understood.
Because there is, you have given a sketch map at page 100. This is according to you, orange color portion is being occupied by Mr. Chatterjee.
Now they're disputing.
They are disputing. Now a commissioner has been appointed. Now let us assume the commissioner gives a report, which may be against one of the parties.
Right.
So if both of you agree to that, well and good. If it is against one of, the parties, then it is to be adjudicated.
Right.
So you cannot take possession of a portion of the property.
Right.
So is it not better, Mr.
Banerjee,
Banerjee, the entire miscellaneous appeal to be decided once
Lord,
for all?
no. Lord, my submission is no. Because silver line case, my Lord, exactly the same case on the in whichever portion he is occupying, he knows better than me. He is a judgment debtor's representative. The question would be whether his defense taken in Order 21 Rule 97 is entitled in the law or not without taking any evidence.
Yes.
Kindly look to the not exactly same case.
Mr. Banerjee, I appreciate that. Take that point in the miscellaneous appeal.
No, whether he is a trespasser or not. He, without any condition. No, without any condition. 12 decimal, 10 decimal. According to their own petition, they are occupying.
Mr. Banerjee, I'm telling you.
No, without any payment.
This order, that
is wrong, my lord. Without any payment, that is wrong.
Mr. Banerjee, it is to be assessed.
What assessment has to go there?
Assessment also has to be
Lord,
made.
that is why, my lord, I have brought a judgment. The court can on the floor. Assessment, my lord, I have given that.
Assessment, Mr. Banerjee, you have documents, you may produce judgments to show that yes, he is liable to pay occupation charges. But what would be the quantum in respect of these 10 kathas? That also some documents are to be produced to ascertain what is the occupation charges.
He is required to, the Lalne district judge ought to have said that you file objection against this.
That is why I'm saying
of that.
There are two ways of going to that. One is for remanding the hearing of the application for stay for the purpose of deciding as to the quantum of the occupation charges. That is one aspect of the matter. So whether it will be stayed or not, or the other way around. So this order was passed sometimes in 22nd of February 2024. More than a year has elapsed. I can direct the miscellaneous appeal to be heard out. Once for all, you raise the point, Order 21 Rule 97 at the instance of Mr. Chatterjee's client is not maintainable.
Lord, that part is concerned, your lordship, kindly look to this. Lord, I shall argue before your lordship that in terms of the case of Silver Line Forum, Silver Line Forum case, my lord, reading on the basis of Order 21 Rule 97, my lord, the petition was rejected summarily on the relying upon the objection filed by the No. What I am telling, relying upon their statements in the petition under Order 21 Rule 97, 101, then, my lord, no trial is needed. The Supreme Court held no trial is needed. He followed that. Trial judge followed that. And what is the trial court judgment? Kindly read that.
My lord is not
The trial court judgment.
Yes.
Against which the appeal was preferred.
Where is that? That report will be directed to be filed before the trial court. So, yes. That is why I have not taken it on record.
Page 92. Lordship, kindly come to page 92, my lord.
92.
Kindly come to page 92. Page 92. The petitioner has stated that the suit property original belonged to opposite party number 2.
Yes.
Who took the same land?
Who is you?
Opposite party number 2.
is you.
No, that originally belonged to opposite party number 2 who took the said land on lease from opposite party number 1. And the name of the opposite party number 2 having been duly recorded in the RS record of ROR as Thika tenant. Opposite party 2 inducted the tenant petitioner as tenant in respect of a portion of the suit property along with a structure by virtue of an agreement letter dated so and so. The opposite party number 2 filed in instant execution case being title execution case number so and so against the opposite party number 2 before this court, but to resistance on behalf of employee of the petitioner, aforesaid decree could not be executed. And after the petitioner through their learned advocate inspect the case record, and petitioner for the first time came to know that opposite party number 1 had obtained a decree of eviction against opposite party number 2 from the Honorable Calcutta High Court. The petitioner has stated that the opposite party 2 had obtained the decree of the Honorable High Court.
Mr. Banerjee, you can come to the last paragraph of this page. I think others are those. It is contended by the opposite party number 1 of this case. Last paragraph
the
of
decree
that
of
page.
eviction was passed by the Honorable on 2 grounds. That is defaulter of payment of rent since 1957. Judgment debtor has illegally sublet a major portion of the suit premises to different person without prior consent from the decree holder. It is not the contention of the petitioner that lease agreement was subsequently renewed or consented by the decree holder. Therefore, third party to that judgment who is claiming his tenancy right or lease right through judgment debtor is also bound by the decree of eviction passed by the Honorable High Court. Not exactly identical case in Silver Line case.
So this is the only issue.
Mr. Banerjee. Trespasser on the basis of his.
I appreciate
He is
that.
liable to pay.
I will direct the miscellaneous appeal to be decided on the next date. This is the only issue, law point. You will be relying upon that judgment, it will be decided on that.
Without granting any adjournment to either of the parties.
Yes.
And my lord, without serving any notice to, because other parties are there have been added. Lordship kindly look to their, yes, for that, my lord, they are not appearing. Summons are being served on them. They are not appearing. That is why matter is delayed. Appeal could not be heard. Although the order was passed, but factually, my lord, appeal was not heard. So that it can be pending for years together.
Respondent number 2 is the judgment debtor.
2 judgment debtor will not appear. They are not appearing. Therefore, that may be dispensed with. Yes. That may be dispensed with. They are not appearing because your judgment debtor is not opposing.
Yes, I appreciate. This order was passed on 22nd of February. Mr. Chatterjee, have you put in the requisites?
Lord, contest between degree holder and them.
Yes.
Not judgment debtor.
Instruction, I'm told yes.
What is the fate? They have appeared. Service, what is the effect of the
No,
service?
they didn't appear.
Haven't appeared.
No, service complete.
It's not something that I've seen. So it's on the basis of instructions that I'm saying. Requisites have been put in, but the department has taken steps, but they have not appeared. But
May not have appeared, but if the service is complete, the appeal is ready for hearing. So I'm recording your submission.
kindly do not record, then I will be in difficulty with
Why? Your instructions, that is your instruction.
On instruction, he is submitting.
Yes. The senior advocate has to take instructions. All submissions are to be on instructions.
Yes. He is senior advocate after all.
Yes.
Whatever he submits, right.
On instructions. No, Mr. Chatterjee, that is the instruction of if.
So the requisites have been put in. No, I have not seen. That's why
You have not seen, your instruction is.
that is not correct, Willard. I will have to take responsibility for that.
All right, I'm keeping under the heading to be mentioned.
On Monday.
Let me see, Monday is the.
No, Tuesday. Lordship, then Tuesday.
Monday.
Because I will have to look into this.
Not here, Mr. Mukherjee.
Kindly appreciate one thing.
in
Milord,
the trial.
Mr. Chatterjee,
No,
please, please.
certainly
Milord,
not.
only
Mr. Mukherjee, have you received your remuneration?
Milord, not that, not that.
You have not received your remuneration.
No, yes, I have received.
I will record that, keep it with you.
No, no, no.
You
What
have
I
to
am,
do some
what I am
duty, Mr.
suggesting,
Mukherjee.
Milord, kindly see. What?
Justify the.
Milord, Justice Basu, Milord, has directed me to take assistance of Milord the Milord survey knowing person, Milord appoint those person and under whose Milord supervision the entire work Milord has to be done. Milord, I have named, my report is ready. I have named that survey knowing person, Milord, including his credential and all that.
His report, it is your report. You will have to prove it.
Milord, let me
Sir,
circulate that and file it before
no,
your
that's
lordship.
not
If it is a piece, if
I
it
am
is a piece of
opposing.
evidence before the trial court, even as per your lordships, whatever way your lordship.
This was the commissioner appointed in exercise of the powers under Order 26, Rule 10.
Through an officer of this honorable court.
Order 26, Rule 10, 9.
Nine,
Order
nine,
26, Rule 9.
Rule 9.
So the procedure under 10. So it will be an evidence in the proceeding
Decided by
and the parties will have a right to examine.
Lord, my submission is to this, Lord, I must submit before,
excess.
no, to this, Lord, I am submitting before the Lordship. Lord, is it required, my Lord, in a proceeding under Order 21, Rule 97, how much I am occupying and how much they are occupying? Is it required under the law? No.
Mr. Banerjee,
I am saying no.
Mr. Banerjee, you have invited this.
No. Lord, because his Lordship view was, I shall allow you to take possession of the other person. That is why I invited, when I submitted. No, that is not because Supreme Court said that.
All right.
That question cannot be adjudicated. Lordship, kindly look to that. I have brought that
Let me
judgment.
ascertain what is the fate of that service. I am keeping in the next week. I am fixing a date for that. So, Ashwin.
Next week, Tuesday, your Lordship, kindly to be mentioned, Tuesday, so that, my Lord, I can take the copy.
You take instructions
on
that will give you
Monday
3
itself.
days.
Monday itself.
3 working days, I will give it.
Lord, because 5, 6, I shall not be here. That is in it.
All right. After hearing
as admissible evidence on record in view of the judgment of the division bench. Why should I go into that? Because that question cannot be the question to be determined in the proceeding under Order 21 Rule 97. Only question is whether you are bound by the degree or not.
The court with
Whether you are bound by the degree or not. Yes, whether he is bound by the degree or not. If he can satisfy the court, he is not bound by the degree, then degree will not be executed. So far, his portion is concerned. That is the law.
Shantilal.
Extreme urgency is not one
Which
of the
matter?
learned advocate, not in the list. May I pray not for Monday, not as a urgent motion, not one of the learned advocate, not who appeared before the trial court for the client, not he has been named in a police complaint. Why? He has gone there for the purpose of assisting the special officer appointed by the court under order 39 rule 7 or 26 rule 9. Not the suit itself is not maintainable. 711 application pending.
Second paragraph,
Now, without waiting for the state of this revisional application, the learned judge is hearing this application wherein the state of the learned advocate is involved.
Because he's got to not assist someone.
But this was pursuant to an order passed by a coordinate
That
bench.
order is pending, Lord. That is challenged before your lordship's court. Suit is not maintainable. This on
No. Coordinate bench passed an order. This is
that is in our favor. Their writ petition is being dismissed, holding that I have a sanction plan.
What is the item number?
But no, it is not in the list. It was in the list. Lord, kindly enlist.
Where is the file?
That is, I shall ensure that the file will come.
Dekhi. Mr. Mukherjee, put the urgency in the mention.
Yes, telling the lordship the urgency. My lord is considering it.
Put it in.
Kindly, Lord, list it not at the top, Lord. Otherwise,
I understand.
kindly direct the matter to appear at the top.
It's a monthly list. One word or two?
ठीक है